The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court. Please be seated. Welcome you. We're happy to be here with you today. We will hear argument first in number 21-6206, Nelson versus Doe. Mr. Shorman, when you're ready.
Good morning. May it please the court. My name is John Shorman, and I represent the appellant, Edward Nelson. Mr. Nelson is an inmate in federal prison, has been for some time.
Can you talk just up a little bit louder?
Yes, ma'am.
Thanks.
Sorry. He seriously injured himself back in March of 2016 when he was in a federal transfer facility in Oklahoma. He fell off a bunk, landed on his head. It was about 6 feet, and he damaged his spine. From that point forward, he's been under treatment until the present time, but it's actually took about 4 years for him for the full diagnosis of his injuries to be developed. He now suffers epilepsy, Parkinson's, a host of neurological problems, and severe spinal injuries that might, according to the latest tests, might actually be fatal. But over the course of that 4 years, he was subjected to what can only be described as deliberate indifference of his condition as he was transferred through several facilities in the federal system. This portion of the case concerns his time at the United States prison in Hazleton. And the defendants in the case are the warden, Mr. Coakley, a lieutenant in the special housing unit, Mr. Sewell, and 2 doctors, Doctors Mims and Bird, forgive me. The district court dismissed the case under both a motion to dismiss combined with a motion for summary judgment on grounds concerning what we call the Hazleton defendants, the warden and the lieutenant, finding that there was a lack of deliberate indifference. Since that decision and since the briefing in this case, this court has issued an opinion in the case Fowler v. Amonet. Fowler is spelled Pfaller versus Amonet, Amonette. It was published by this court on December 15th, 2022, and it discusses the analysis of deliberate indifference. And essentially, there's the objective prong and the subjective prong of deliberate indifference. The objective prong is a constitutional right. It's been recognized that medical care of a serious condition is a constitutional right, and that's really not an issue in this case. What an issue in this case is the dismissal on grounds and a finding that there was no deliberate indifference, primarily because, according to the district court, the 2 non-medical defendants, Warden Coakley and Lieutenant Sewell, were relying upon medical advice. That's not actually found in the record. The amended complaint lays out that both the warden and the lieutenant studied the records, knew that this man could not stand unassisted, knew that this man required a wheelchair.
Ask you a question. I understand that part of your complaint. I don't actually understand how the doctors are implicated in your theory of liability, because it seems to be that your claim is that your client was put in the shoe without an assistive device. But your brief says expressly that the 2 doctor defendants had nothing to do with that. It wasn't a medical determination. They had nothing to do with putting him in there, and they did not recommend that he should go in there without an assistive device. So how are they on the hook on count 1?
Well, they did not recommend that he be placed in the SHU without a device. That's true. But since it wasn't
a medical judgment. Putting him in there had nothing to do with a medical judgment.
But up to that point, it had not, he had asked for assistive devices. This man could not walk. This man could not stand without support. But throughout his travails, it was assumed he was lying or putting it on or trying to pull one off on the system. But
You're saying that your complaint as to the doctors is not about the placement in the shoe. It's just about a prior failure to prescribe an assistive device?
yes, ma'am. That it's the lack of the treatment that he received. Even from
I
the
see that in count one, but
well, as to count one, it really does focus on the district court's decision that there was no participation in the decision to place him in the shoe without an assistive device. I think that's contradicted by the amended complaint, where it's laid out that his records indicated that this man could not stand. Now, he was placed in the shoe on 2 separate occasions for 3 months on each occasion. Just the fact that he went in there a second time after his condition when he came out the first time would indicate that this man obviously needed an assistive device. If he was faking it, then he deserves an Academy Award. This man developed sores on his knees because he could not walk. He was dragging himself around, sores on his knees, where it's undisputed that he received medical treatment to draw off the pus from sores that he developed. He also strained his back severely by literally dragging himself across the floor. And when he did get out, his medical condition, his spinal injuries, were of course seriously exacerbated.
Can you talk to us a little bit about the Bivens issue?
Well, Your Honor, as we stated in the supplemental brief, in terms of the Bivens issue, this is not presenting a new set of facts. This case is very much analogous to Carlson. Carlson was a case where an inmate in a prison was denied medical care. He sued on a personal injury. And in this case, it's exactly the only real distinction between this case and Carlson is the fact that this inmate is not yet dead. Carlson, of course, he died and it was brought by his estate. So I don't believe we're going into any new area that would make the Abbasi case applicable to this set of facts. I believe that there is no alternative to Bivens outside of the FTCA. There's no government alternative. The government raises the grievance procedure as an alternative that my client could have participated in. But the grievance procedures, he filed one after another, complaining about his worsening medical condition. They were all denied. All those really are in this case is an exhaustion of administrative remedies. They're not an alternative to this lawsuit. They're not an alternative to Bivens.
Can I ask you, just on the Bivens question? I mean, I can think of 2 possible distinctions, and I just want to give you a chance to address them. One would be that at least your case is not at least entirely about a denial of medical treatment, as as it's alleged in the complaint and as you explain in your brief. The decision to put your client in the shoe without an assistive device was an administrative decision, not a medical decision, not made by doctors. And that does seem to me that it takes us a little bit out of Carlson, because it is not, at least mostly, just about medical determinations. It appears to at least be intertwined with this administrative decision to put your client in the shoe.
Obviously, yes, there's an overlapping administrative decision, but if he had been properly treated, then I don't believe that it could possibly be the case that he would be sent to the shoe without at least a walker, if not a wheelchair. He had asked for that. This was not something that, it's not as though the day before he was going to be sent to the shoe, he suddenly pretended he couldn't stand. He couldn't stand when he entered the Hazleton facility. The record shows that he was in need of support.
I mean, the medical record shows that he was examined and the doctor found that there was no objective need for an assistive device.
Precisely, because the doctor was not adequately treating this individual, because when he was sent outside the system to Dr. Druru, at the West Virginia university, it was found that everything he'd been complaining about was true. He had a host of.
I got us a little bit off. I apologize. I got you back into the facts. I did want to raise this other issue, or at least concern I have about the Bivens issue. As you presented the case at the very beginning, you did explain this is part of a 4-year claim involving 4 different facilities, a huge number of defendants, some doctors, some not doctors, spanning a 4-year period of time, involving not only the treatment at each facility, but also sort of continuity of care between them. And it does strike me that the scale of this case is very different from Carlson. Is that something we would look at? Because in Tate, we talked a little bit about that.
Well, it's very unfortunate that the scale of this case is driven by the fact that he was repeatedly denied adequate medical care. Objectively, this man is suffering from the incident from 2016. That's when it all started. He's in much worse condition today than he would have been had he received adequate medical care. And the fact that this portion of the case only relates to Hazelton, I don't believe distinguishes it from Carlson, because there are other aspects outside of the responsibility of these defendants. But in terms of Abbasi and the court's decision that it was not going to extend Bivens to new fact situations, I don't believe that this case presents a new fact situation. It's certainly within the ambit of medical care in prisons, and yes, it was an administrative decision in which 2 administrators participated in to place this man in the shoe. Yet that decision largely flowed from this misdiagnosis or failure to diagnose, or simply failure to believe their own eyes that this man couldn't stand and walk.
Mr. Shorman, if I could ask you a question. You alleged in your complaint that Mims and Bird approved the decision to place him in the SHU without the assisted device. You said that Mims and Bird knew Nelson could not walk and approved the decision to place him in 23-1 lockdown without a wheelchair or walker. And I seem to be hearing you say now that they didn't actually approve the decision. So which is it? Did they approve the decision or not?
Yes, I believe that may have been inartfully phrased, Your Honor. They did not approve the decision initially, but they certainly became aware because of this man's. He was there for 2 separate periods of 3 months each, 6 months total. And as he was dragging himself across the floor, his medical condition worsened. Even after that period of time, the doctors didn't come in and say, give this man an assisted device, a walker or a wheelchair, because he's injuring himself. So there was, if not approval to go into SHU without those devices, there was a consent that he can continue to remain in SHU, suffering the.
So just looking at your brief, there is no evidence or allegation that medical personnel recommended placing Mr. Nelson in the SHU, or that they recommended he be placed there without a walker or a wheelchair. There's no medical, the court did not and could not point to any medical professional who stated that in their judgment, Mr. Nelson should be in SHU crawling around on the floor. So I just think your brief could not be clearer on this point.
Right, Your Honor. And that really goes to the point that the administrative defendants were dismissed by the district court on grounds that they did not participate in the constitutional violation. But in fact, the whole decision to place him into the SHU without this device was an administrative decision by the 2 things. The issue I've
misunderstood, but I thought that it was the prison policy that you weren't allowed to have these devices in the SHU. Is that correct?
Well, that's somewhat unclear, and certainly not clear enough to be the basis of a summary judgment. The policy was you can't have these devices in SHU unless there's special circumstances. Those special circumstances were never developed in this case, but those special circumstances must be that this individual cannot ambulate, cannot stand without an assistive device. Otherwise, you're saying this chap can't walk. He can either lie in his bed for 3 months or crawl around. Now those special circumstances must include somebody who is unable to walk.
Counsel, can I ask a question?
Yes, ma'am.
I think that you are, I want to say something and have you respond. It looks to me like you are kind of boxed in here. You want to argue, and you did in your brief, that the non-doctor defendants in this case, the administrative defendants, can't rely on a medical judgment of a doctor as their sort of defense, because this had nothing to do with a medical judgment. This was a purely administrative decision. That's what you just said. But I am having trouble squaring that with Carlson. I think I understand why you have to argue that, but I think it gives you a problem under Carlson, because now you're saying this is not a medical judgment. This is an administrative decision.
I understand, Your Honor, and if I may just answer the question while I'm out of time, it's an overlap of facts, and if the law now is that what the court stated previously is siloed and you can't go beyond any interpretation of those facts, then that's the law and this court will determine it. But my position is that Carlson laid out an area where there is no remedy for a constitutional tort outside of Bivens. And that's what we have here. There is no remedy for a constitutional tort outside of Bivens. And I believe that it all revolves around his medical condition, and it all revolves around the treatment. If he had a walker, if he had a wheelchair prior to being sent to SHU, then I think it would have been, even though it had been denied to him on grounds that the medical professionals deemed to be appropriate. We know now that it was not appropriate, that it was negligence not to give him that. So I think it's so intertwined that under Abbasi, this would be considered to be a Carlson set of facts. Thank you, Your Honor.
Good morning, and may it please the court. My name is Max Nogue. I'm an assistant United States attorney for the Northern District of West Virginia. I represent the appellees in this matter: USP Hazleton Warden John Doe, USP Hazleton Shoe Lieutenant Doe, Dr. Gregory Mims, and physician assistant Lee Bird. The district court's order dismissing plaintiffs' Bivens and tort claims should be affirmed for the following reasons. In Egbert, the Supreme Court made clear that creating a cause of action is a job for Congress, not the courts. And Bivens claims will remain unavailable in all but the most unusual circumstances. In the decades following the Supreme Court's decision in Carlson in 1980, the court has rebuffed every request to expand the Bivens remedy. Cases sharing almost parallel circumstances, a similar mechanism of injury, or other similar superficial traits with the three recognized Bivens cases do not justify an extension thereof. Instead, Bivens plaintiffs must satisfy a narrow two-step framework that was set forth in Abbasi and narrowed and clarified in Egbert. Under that now narrowed framework, Mr. Nelson's deliberate indifference claims cannot survive. The two-part test asks whether the case presents a new context that is meaningfully different from the three recognized cases, and whether there are special factors counseling hesitation before extending a Bivens remedy. There is a substantial overlap between those two steps, often leading to the single question of whether Congress is better suited to create a damages remedy.
Why don't you start with, why is this one meaningfully different, to the extent that there is a claim here that these two doctors just consistently acted with deliberate indifference in refusing to prescribe this prisoner an assistive device? Why is that not a Carlson claim?
Well, first, Your Honor, a new context can arise when special factors that previous Bivens cases did not consider are at play here. And because there are several special factors that were not considered in Carlson that are now available.
You're saying this is this is not a meaningfully different context. You want to make a different argument?
No, Your Honor, there are.
She asked you about the meaningfully different
Okay.
context, so maybe start with that.
I apologize. Thank you. Well, Carlson was a specific incident of gross medical misconduct, which led to an inmate's death. And that occurred over a period of 8 hours. The decedent in Carlson was a chronic asthmatic He was hospitalized and physicians recommended steroids and transfer to a new BOP facility. There was no examination or treatment for 8 hours after the decedent went into an asthma attack. The BOP employees administered a contraindicated treatment. They used a known defective.
Yes, I don't understand why this is where we're starting. Are you suggesting that if it's not about asthma, it's not a Carlson case anymore?
No, Your Honor.
Okay, so what's the
that is-
difference?
Cut to the chase.
In comparison, the allegations here that Mr. Nelson has alleged have taken place in 10 separate civil actions over a period of about 7 years now. And it involves a fall that took place at the Oklahoma City Transfer Center in March of 2016. And then he was transferred to USB Big Sandy, whom he sued. Then he was transferred to USB Hazleton, whom he sued, USP Canaan, and so on and so forth.
So it's the length of the problem rather that distinguishes this, that makes this a new case?
It's one of the factors that would take this into a new context.
I thought, yes, okay, so that's what the new context is? If that's so, couldn't you take a specific portion of what happened here and say it was like the context in Carlson?
No, Your Honor, I don't believe that that would be the correct analysis.
Well, that's interesting, but does the Supreme Court say that?
Yes, I mean, the Supreme Court says any meaningfully different set of facts takes it into a new context.
I understand that they say that. The question I'm asking you is if one portion of this was like Carlson, would we have a Carlson case?
No, that would not be enough
Why not?
Why not?
because any meaningfully different factual difference or factors that were considered in Carlson.
Is the meaningful factual difference here? Again, let's assume, I understand what you're saying about the scale of what's being alleged here, but if we can just isolate out these defendants, these doctors, these non-doctors, their combined deliberate indifference through refusing to give this guy an assistive device. Why is that meaningfully different from Carlson?
Well, Mr. Nelson's case is really about a dispute of the medical care that he received. And in Carlson, he received no care, the decedent.
That just is a way of saying he might lose his claim because this is just a malpractice claim. But I don't think whether it's a good claim on the merits or not has been identified as a meaningful difference for purposes of whether there is a cause of action. Do you see what I'm saying?
I agree, yes. And I think the overarching, what takes it into a new context is the fact in Carlson, the plaintiff had a damages or nothing remedy. And here, Mr. Nelson's claims were amenable to alternative remedies. And he exercised the administrative remedy program. He filed for injunctive relief. He could have filed a habeas petition, which he did not.
So without those remedies, you would say that this is a Carlson case?
No, I would not,
I mean,
Your Honor.
you're not losing anything because you're right. There are these alternative remedies.
I would
There's
not.
no way of distinguishing it straight up.
Well, there are many facts that could distinguish it. For instance,
I'm talking about for Bivens purposes, okay?
for Bivens purposes, he was treated. Mr. Nelson was provided treatment. He was taken to outside providers at WVU and he was analyzed and examined. And then what distinguishes that from Carlson is there was no treatment. He was left untreated for 8 hours and ultimately passed away.
So, Mr. Shorman, you're getting back though to the point that Judge Harris brought up. You seem to be relying on the fact that the degree of alleged indifference is less. Is that correct? That's the distinction you're drawing with Carlson, that this case involved a lesser degree of indifference and therefore is not within Carlson?
I think that would be one of the factors that would create a new context, is the fact that the allegation in Carlson resulted in the inmate's death. And here, that is not the case.
So to have a Carlson claim, you have to have the plaintiff die?
No, but that would be one factor that would distinguish this case from Carlson.
I mean, also it would be different because it's not about asthma, And I appreciate what you were saying. The Supreme Court has absolutely like instructed that a difference doesn't have to be huge or anything, but it does have to be meaningful. And I'm just not clear on how, well, why sort of the particular degree of alleged indifference or, you know, some of the distinctions you're pointing to are kind of meaningful.
Well, I believe any factual distinction could be a meaningful difference. The court never really specified what makes it a meaningful difference.
So just like exact same facts, but instead of asthma, he had this plaintiff, everything happens just the way it happened in Carlson, but it's not asthma, it's an underlying heart condition. Meaningful difference?
I would agree that it's a meaningful difference.
You think that's a meaningful difference?
Yes, it's a factual distinction that
Happens on a different day.
it would require
In Carlson, it happened on a Tuesday. For this plaintiff, it happened on a Wednesday.
I think we're splitting hairs there.
Okay.
I am prepared to argue and the facts at issue here in Nelson. I cannot speculate what would survive
That's
under.
not very helpful to us because we have to make a rule that is followed in subsequent cases that gives somebody who does have these kinds of differences, give them an idea whether they have a Bivens claim or not. And you are not being helpful to us in that pursuit. I understand you want to win your case, but you have to understand where we're coming from. We want to make a precedent that other people can follow too.
I do, Your Honor. And the government is analyzing these cases individually and on a case-by-case basis. I cannot speculate as to what remains under Bivens and Carlson. It would be done on a case-by-case basis. I would rely most heavily on what creates a new context in this case is the fact that there were numerous special factors that were not in existence when Carlson was decided and therefore not considered in Carlson. And most importantly, that would be the administrative remedy program, the exhaustion requirement that was incorporated and codified by the Prison Litigation Reform Act, and the other types of statutory recourse that Mr. Nelson would have, and he took advantage of. Those were not considered to be special factors in Carlson. Carlson rather focused on Bivens as a deterrent, and the analysis in the past 43 years has changed.
So are you suggesting that Carlson is not good law? If Carlson is decided, the case comes, the exact same case comes up today, it's not a Bivens claim. Instead of Carlson, his name is Marlson, but every other thing is the same.
I apologize to provide the same answer, Your Honor, but we would do a case-by-case analysis.
Well, you have the case. You have Carlson and you have Marlson. Exactly the same facts, exactly the same. Every single thing is the same.
Well, I mean, I believe that would not create a new context if everything was the same. However, there would certainly be differences in the treatment that was available at that time in comparison to 40 years ago, the facility potentially that the inmate was designated to.
Just a few minutes ago that all these special factors that you have the remedies and all of that were making the difference. What I'm saying to you is that none of that exists because this Marlson is exactly the same situation as Carlson.
Well, in Marlson, in the hypothetical, it would not be possible for it to be exactly the same as Carlson because of the development in the administrative remedy program, extensive legislation in the area.
So there is not possible to have a Carlson claim now because there are all these new things. Is that correct?
I believe that there would be several meaningfully different factors at play.
I understand that. And what I'm asking you is it possible to bring a Carlson claim now?
Well, I believe the Supreme Court did leave at least the door cracked open for future claims that do not present a new context. However, in Egbert, the court specifically said if there were special factors that were not considered in Carlson, then it automatically takes it out of the new context analysis and into step two.
Sir, I think I credit you that you've read and understood the Supreme Court cases, but just credit us that we have too. And what I'm asking you is today, is it possible to bring a Carlson claim today?
Well, I believe that the Supreme Court did leave the door open for cases that do not present a new context.
but you say that all these special factors
Right,
would
Your
do
Honor.
you in. So that's why I'm asking you.
I believe that it would be factually near impossible to bring a case that was identical to Carlson, given all the factors that I've discussed.
That's what I thought.
Ask you a question on the merits of the district court's grant of summary judgment on the deliberate indifference claims. So the district court granted summary judgment, I think, on count one. And he did that without allowing, or it did that without allowing any discovery, even though the defendant had asked for discovery. Why is that okay?
It would be okay because ultimately, based on the medical records that were attached as exhibits to the briefing, it at least created the understanding for the court that this was a dispute of medical care, which is not an actionable Bivens claim, at least at that time.
I'm sorry, I'm assuming for a second that we are at the merits, that we're past the Bivens question.
The findings in the district court order dismissing the case were that Mr. Nelson was treated, he was taken to outside facilities, and opinions were developed by Dr. Mims and PA Bird that Mr. Nelson was in essence creating or diagnosing himself and fabricating the extent of his injuries.
Well, I think he alleges, right, that at least one of the non-medical defendants saw him in the shoe crawling around on his hands and knees. And if that's true, doesn't that maybe warrant looking into?
I believe it would, and Your Honor. However, there were declarations that were attached as exhibits. A declaration of Dr. Mims stated that while Mr. Nelson or other inmates who may need an ambulatory device are not allowed to have those devices inside of the shoe, they would be provided assistance to ambulate in the shoe by correctional officers, and that device would become available upon leaving the shoe cell.
Right, but I believe the plaintiff is alleging that that didn't happen, and that's why he had to crawl around on his hands and knees, and that at least one of the defendants saw that, and the other one, he alleges, knew that because he read his grievances while he was in the shoe saying, nobody is helping me walk around, I'm crawling around on my hands and knees. And if all of that is alleged, I guess I'm just not clear. I think I understand your point more with respect to the claim against the doctors because they are medical records. I sort of understand the logic, at least, of the idea that that might be enough to resolve the claim on the paper. But as to the non-medical defendants, it's just not 100% clear to me why discovery wouldn't have been warranted to see if these claims could be borne out.
Well, the case law encourages an early resolution in some of these Bivens claims against more of officials that have decision-making power. And in this case, while the case was dismissed prior to discovery, there were exhibits, medical records, BOP records.
What was there? There wasn't a declaration, say, from the lieutenant saying, no, I did not see him crawling around on his hands and knees.
That's correct. However, under the current case law as it stands today, under this court's decision in Tate, we would take the position that it would be a conditions of confinement claim that is not actionable under Bivens.
That seems like something you might have mentioned before when we were asking you whether this case was different from Carlson. So you would say that again?
This case is a combination of a conditions of confinement claim as well as medical deliberate indifference. And that also creates a new context under the first step. I apologize for not recognizing that question earlier. Certainly the decision to place Mr. Nelson in the shoe cannot be made by Dr. Mims or PA Bird. That would have to be made by the warden or the unit captain to place him there.
Isn't there an allegation in the complaint that he also was denied the device when he was not in the shoe?
I believe that is an allegation that was made. However, the attachments to the briefing prove otherwise. It indicates on the medical records that Mr. Nelson was issued a walker to assist with ambulation. However, there is an overarching dispute that Mr. Nelson actually needed these ambulatory devices. When he was designated to USP Big Sandy in April of 2016, just about 7 months before he was transferred to Hazleton, Mr. Nelson was observed doing push-ups and different exercises in his cell doing jumping jacks. And that was taken into consideration by the medical officials in this case.
Well, was the suggestion that he had blisters on his knees and so forth, they had to be treated? Is that disputed?
I think for purposes of this argument, we would assume the facts alleged in the complaint is true.
So he purposely hurt himself. Is that what you're saying?
No, I'm assuming that the facts is true is that he could not ambulate and for one reason or another
He
was.
told me he did jumping jacks so that he could not, he got the blisters, et cetera. He didn't have to, so he hurt himself intentionally.
I would not say that we would not take the position that he did it intentionally. However, as part of the diagnosis and the determination of what Mr. Nelson needed, the fact that he was observed doing jumping jacks and push-ups would play into the physician's decision.
So, did I understand?
Mr. Nogue, aren't you arguing disputed facts? I mean, it seems to me that this portion of your argument is making a case for allowing the case to proceed, at least as to the administrative defendants.
Oh, Your Honor, this case.
Those aren't established facts in the case, uncontroverted facts in the case that he was doing push-ups in a cell, but yet you seem to be arguing the facts of the case from your perspective. And why aren't you making a case to at least send it back as to the administrative defendant?
Well, I think that this argument, for purposes of this argument, it would be addressed in two ways. At first, we looked at whether the Bivens claims were actionable any longer. And in that case, we would do an analysis on assuming the facts alleged in the complaint is true. Judge Harris had asked me a question regarding the merits of the case. And because the government filed both a motion to dismiss and a motion for summary judgment, we are disputing those facts in an attempt to establish the fact that this is a mere dispute of medical treatment, which is not actionable under Bivens.
Did I understand you correctly? Did you say that because there was no discovery at this point, we should accept the allegations in the complaint as true?
Under a 12B6, we would. And I believe that looking as to whether Mr. Nelson, I see I'm out of time. May I answer your question? Whether Mr. Nelson's claim is actionable at the pleading stage, whether it comports with the two-step Egbert analysis, we would assume those facts is true in the amended complaint.
And what about for purposes of reviewing what appears to me to be the district court's grant of summary judgment on the deliberate indifference claims? What do I do there? Do I look at the facts of the complaint, given that the plaintiff wasn't allowed to do any discovery? What do I look at?
I would look at the briefing, Your Honor. We've introduced exhibits and evidence that were authenticated by declaration that would create a dispute of fact.
Well, if they would create a dispute of fact, why was summary judgment granted?
I'm sorry, it contradicts the facts as alleged.
Well, so where does that lead us?
Well, I don't believe it needs to get to that point. Under the new case law that came out after this case was briefed, the case would end under an Egbert analysis, and there would be no reason to look at the merits of this case.
Okay, if it doesn't end under Egbert, what do you think we should do?
I believe that you should affirm the district court's.
And how do we do that, given that, as you say, there are exhibits now introduced by the defendant that contradict the allegations in the complaint, but the plaintiff hasn't had an opportunity to do discovery?
Well, the district court found that there was no disputed fact and that Mr. Nelson received the treatment that was applicable.
I did find that as to the doctors, I didn't quite understand what we do with the non-doctors who are not alleged to have made any medical judgment at all, just to have made this administrative decision, allegedly knowing full well that he couldn't walk and was crawling around on his hands and knees.
Well, the warden and the shoe lieutenant certainly relied on the medical advice and the findings of.
It's not like there's anything in the record saying that.
Well, they would not necessarily play a role in the medical decisions. The decisions to place Mr. Nelson in the shoe would be in their purview. Thank you.
Thank you, Your Honors. Well, I take it from my colleague's argument that the question is this meaningful difference, that this meaningful difference really is without any meaning, that the Supreme Court basically is saying, if you don't have a duplicate of Carlson, you don't have a Bivens claim. But the Supreme Court could have said that. The Supreme Court could have said there's no life left in Bivens, but it didn't.
Close to it.
But here, and I certainly don't envy your role, Judge Motz, in trying to craft this rule, given what you have here. But I think that the essential case is that in Carlsbad, he was denied medical care. Now, he died in 8 hours because of that. The allegation was he died within eight hours because of that from asthma. In this case, it's still going on. It exacerbated a condition because he was denied medical care. And, you know, the facts, I think, are very much in dispute. This idea that he was doing jumping jacks, we dispute that observational piece of evidence because we have what is undisputed in October 2017 that from Dr. Duro, the West Virginia doctor, the outside doctor, that everything Nelson had been saying about his condition was true. Neurological disorders, imbalance disorders, recommended him for MRIs and everything else. So the fact that these medical professionals assumed he was lying, given all his conditions, given the persistency of his symptoms, is a denial of medical care, and it's right in the Carlsbad. I'm saying Carlsbad. I'm sorry. It's right in the crosshairs. I don't see how there's any meaningful difference there. Now we get
just the very first thing that you pointed out. I mean, I'm sure you have read these Bivens cases from the Supreme Court. The whole, you know, the Bivens claim gets smaller and smaller and smaller and smaller, and any difference, not an insignificant one, but any difference in the context is a reason not to find a Bivens claim. And isn't the very fact that you told us that in Bivens, the death occurred after 8 hours, and here there were months and months and months. Is that a different context?
Well, it's a different fact, definitely, but a different context? No, I don't believe so, Your Honor. A different context would be that it didn't involve medical negligence. It didn't involve professional negligence. The fact that he died and wasn't subjected to 4 years of punishment because of a misdiagnosis might be to his benefit.
See, the problem is there have been subsequent attempts to find a Carlson claim that have also involved miscare, medical miscare in prisons. And none of them have been found by the Supreme Court to be sufficiently like Carlson to succeed. And I just wonder, given all the language, that this isn't a difference.
Your Honor, I do believe that it's set up in Carlsbad because it goes from an initial immediate misdiagnosis. There's a fact that's very much aligned between the two cases. In Carlsbad, it was, hey, this guy's choking. Let's not do anything about it. Shift him off to an emergency room, and he died. In this case, he came to them unable to walk, and they said, "Oh, he's faking it," and didn't bother looking into it again for 2 years. So that there's a very much two facts in line. I think that what might trip us up in this case, but I believe can still put it within Carlsbad, is the conditions of confinement, which my colleague raised. Now, it's true, the conditions of confinement in this case exacerbated his condition, but it doesn't mean that there wasn't an existing condition that was not treated as he went into those conditions of confinement. So the conditions of confinement is an overlay, not the root cause of this man's problem.
You say that, but I'm not going to be able to find it. As I read count 1 of your complaint, this case really was all about the placement in the shoe. Is that not right? never gonna be able to find it.
Well, he suffered his injuries obviously before he went into the shoot. He presented himself with this condition.
There are factual allegations to that effect in your complaint, but it's not what count one says. Count one says he went into shoe and they didn't give him a walker.
Right. He went into shoe. They didn't give him. They didn't give him a walker. They didn't give him that. And he was there for 3 months the first time. 3 months. Even after the first time, when he came out with, we know that they understood the situation because the prison treated him for the sores. My time's up. Unless you have further questions, I'll rest.
Judge Keenan, do you have any questions?
No, thank you.
Thank you very
Thank
much.
you very much. We are sorry we can't come down and shake hands, as is our custom, but we thank you very much for your help today and wish you well. Daniel Hicks versus Officer Ferreira.
Good morning. May it please the court. Ned Parent of Silverman, Thompson, Sluckin and White in Baltimore, on behalf of the appellants, officers Gerald Ferreira and Brian Phillips of the United States Park Police. This is a unusual case in a number of different ways. It's unusual because I believe this is the second time we've actually been in front of this panel in this matter. It is unusual, certainly because of the facts involved, particularly the participants involved in their various roles. It's also unusual, I think, in the Bivens context, because we're a bit of the way through the looking glass, in a sense, in that usually in these arguments, as we just saw, it is the government as the appellee saying that after there's been a finding by the lower court that the Abbasi analysis has gotten rid of a Bivens claim. Here we're on the opposite side, where the government has actually had a jury verdict where they have been found liable under a Bivens theory. I do believe under the Abbasi, Hernandez, and Egbert line of cases, even under this context, this Bivens claim is no longer tenable, and the court should reverse the finding of the district court denying our Rule 59 motion. This panel is obviously familiar with the facts of this case. I would like to dispense with a recitation if your honors are okay to get straight to the heart of our case, because I do think this rests primarily on the first issue we raised, which is—
How long was the trial here?
Trial was all in, it was about 5 days. I think it was about 3 days of testimony and argument. There was jury selection. We may have bled into a fourth day below. It was about a year and a half ago. I do believe it was about 2.5 days or 3 days total of, it was 3 days of testimony and argument. The verdict came back on the fourth day. Jury selection was a prior fifth day.
Mr. Parent, when you're making your presentation, if you'll make sure to address the special interrogatories returned by the jury, because they are particularly devastating with respect to your defendants.
It is, we acknowledge that, and certainly the jury verdict is pertinent to the second, third, and fourth arguments we have raised: qualified immunity, this instruction issue, and the damages issue.
It's like it's relevant to your Bivens claim too, because I mean, maybe this was more before, but still now. I mean, part of the argument, right, is that this implicates Park Service policy, and you have the two agencies, and the policy is to call the supervisor and work it out. And then the jury comes back and says there is literally no such policy. So we take that out of the Bivens. This does not implicate any any official administrative policy of either branch, right?
Well, I understand what your point is, Your Honor. I think if I could bring it back to 1,000-foot level to address where I think your question is going, especially with regard to the jury issue, on the Abbasi argument, I would actually submit that the jury verdict, as far as the court's analysis, is somewhat irrelevant here, because what I find footnote 3 in particular of the Egbert majority to find is that this is almost akin to a subject matter jurisdiction issue that can be raised at any time sua sponte, because it goes as to whether or not an Article 3 court.
I know the part you're talking about. I think they did say, the court did make clear that like you should be prepared to forgive forfeitures. I did not understand them to be saying that this is jurisdictional. And also, I'm sort of not sure it matters. Like, you have in mind that we could write an opinion saying this is a different context for Bivens purposes because it affects or implicates official policy in light of the fact that the jury just said, no, there is no policy. That would be very odd.
Well, it's broader than that. I think if you go toward the judicial guidance aspect, we're going to talk about the new context analysis, because yes, this does arise in a Fourth Amendment context. That's unquestioned, but there are different contours of the Fourth Amendment. There's the contours of the Fourth Amendment that Webster Bivens had, the heightened level of expectation of privacy in his own home from a warrantless search and a warrantless seizure, versus what happened to Agent Hicks in July of 2015, where he is at the side of the road in his vehicle. It's not even his own personal vehicle, it's a government issued vehicle, where the expectation of privacy is at the very end of the contours of the guidance within the Fourth Amendment. This could not be a more meaningful, stark difference between the judicial guidance that would be afforded a situation that affected Webster Bivens versus what was faced by Agent Hicks.
Okay, Mr. Parent, can you point us to any language in either Bivens or its progeny that say that the degree of intrusion is meaningful? Because we have in Bivens an unlawful seizure. We have in Hicks an unlawful seizure. So what is the authority for saying that a lesser degree of intrusion, that is Hicks being unlawfully detained for over an hour, couldn't get out of his vehicle, they wouldn't let him move while the supervisor was being called? What in our case law says that the degree of intrusion is a meaningful distinction once you have established the illegal detention that is a Fourth Amendment violation like in Bivens?
Sure. I think that one case from this court that may provide some guidance is the Aaron Peretti opinion, because this discussion of the difference part of judicial guidance that would be afforded under the alleged constitutional right that's being asserted, giving rise to the Bivens claim, discusses this. I know that there's a part, I think it's the pinpoint site is 135 of Aaron Peretti, makes the discussion about how there are going to be similarities in almost every Bivens case, particularly with line level officers. That was an issue that the district court stressed in its argument. There's going to be line level officers in almost every Bivens case because that's the level of officers that are having the most interaction with civilians whose rights could be impeded. But what matters is not so much the level of the similarities. What matters is whether or not there is a meaningful difference.
And we held in that case that a with warrant search is meaningfully different from what we had in Bivens, which was a warrantless seizure. And that's what we have here. So I don't really see how that case held to. It draws a line, and this case is on the Bivens side of the line that case draws.
I do believe that the difference between home versus car is significant. There is just different expectations of privacy.
And already we were able to cite a lot of literature and cases really emphasizing the fundamental switch that happens in Fourth Amendment cases once you have a warrant. And I don't really see anything like that in terms of various expectations of privacy in the warrantless context.
I understand, Your Honor, and I don't necessarily disagree with your point, but I do feel that for purposes of the Egbert-Abbasi analysis, examining any Bivens case, I can't believe there is a meaningful difference between when you're talking about a litigant who is alleging a Fourth Amendment violation, the difference between whether it's warranted or not, between an event that happened inside their own home with 6 people blasting in, harassing their family, searching, removing him, taking him down and strip searching him as if he didn't have enough indignity, versus what happened to Agent Hicks, where he's on the side of the road, he's running advance for a motorcade. The Agent Hicks does not challenge the initial approach in this case. He did not challenge it at trial. The initial approach from Officer Ferreira that morning was he believed this was a welfare check. He sees a car on the side of the road at 6 a.m. on a Saturday morning. He doesn't know what the car is doing there. He goes in. Even the jury agreed in the special interrogatories that Agent Hicks could have appeared asleep to him. There's a gun on the seat. He goes code 60 because he believes that Agent Hicks is reaching for it. Because of the confusion involved, he called a supervisor to the scene.
And at that point, based on the special interrogatories, everything else is unreasonable.
And I do believe the special interrogatories, while relevant to the other causes of action with regard to the Abbasi analysis that goes to whether or not there was even a cause of action that should have gotten to the fact finder, we brought a Rule 50 argument. We brought Abbasi up in our Rule 50 argument to Judge Grimm. He allowed it to go to the defendant's case. We raised it again at the end of all evidence. He allowed it to go to the jury. Had the district court applied what we believe was the correct analysis under Abbasi under these circumstances, the jury would have never even heard this case because there is no Bivens case to be heard within an Article 3 court. I believe that is where this lay of cases have gone since Abbasi to Hernandez to Egbert. With Abbasi, it was such a new case in terms of Bivens jurisprudence, that all the judges and the bar are trying to grapple with what this means. I think the Egbert decision, and I think even Justice Gorsuch's concurrence in this case, makes very clear that we are to look at these claims that there is a single reason that where Congress should be afforded the right of remedy here rather than the judiciary, then there is no Bivens
We
case.
just handed down our decision in Tate, right?
I'm aware of it.
It says after Egbert, we do the first step. We ask first, is this a meaningful extent? Is there a meaningful difference that would make this an extension? And if the answer is no, that's it. So I'm not sure that we are governed really by the Justice Gorsuch's concurrence so much as at least this panel is bound by Tate.
And I believe the meaningful difference we have in these facts versus what happened to Bivens versus what happened to Hicks is the difference between home versus car. I do think that's enough. I also want to mention with regard to the special factors, certainly there's 2 in particular. We mentioned that this is an interagency policy, but I think the alternative remedy is one that also needs mentioning with regard to whether there's a special factor to counsel extension here. And this is something that I don't believe it is in our briefs, it's certainly in the record. And it was something that it's been hiding in plain sight sometime, which is, I think, is Agent Hicks's other cause of action that he raised in his amended complaint. He brought a Bivens action, but he also brought an action under 42 USC 1985, the conspiracy to interfere with civil rights, specifically 1985-1, which refers to 2 or more individuals conspiring to impede the work of a government official. And that is specific to the specific facts here. You have an on-duty Secret Service who's running point for a motorcade. The allegation was that officers Ferreira and Phillips conspired together to prevent him from participating in that motorcade. He brought that in his amended complaint. I think it's in the joint appendix. I think it's at page 28 is where you find it in the amended complaint. You can see his cause of action. It was well pled under Rule 8. We did not move to dismiss below. We filed an answer. It went through discovery, and the district court granted a summary judgment on that count due to there was no fact supporting that there was an actual conspiracy and any furtherance of it between these 2 officers. Under the Egbert analysis, if there is an alternate remedy available to a litigant in addition to Bivens, that is sufficient. It doesn't matter whether it's successful on the merits. It doesn't matter whether it gives all the results. It's the availability of that remedy. So even in this record, that other cause of action, which was again available to Agent Hicks and was enacted by Congress, I think is a special factor. Another special factor, and I would like to turn the court's attention to a recent case. It's not in our papers. It just came down a couple months ago. It's not dispositive here, but I do believe it's instructed. It's Mejia v. Miller, 53, 4th, 501. It's a 9th Circuit case, came down in November. Situation involved a couple on a UTV vehicle in Joshua Tree National Park. It's Bureau of Land Management. They got into a dispute. They were trying to speed away. The officer shot. hit the woman, they bring a Bivens case. And one of the things that the court says in finding that the Bivens remedy was unavailable here was because it would create, if they were to find a Bivens remedy under that specific fact pattern, particularly the expectation of privacy was something that court specifically alleged, is that it would create a deluge of new Bivens cases into new areas. These are two occurrences that occurred on one time between these officers. The first is a welfare check that involved Officer Ferreira, where Officer Phillips comes in backup. Then the second part is in isolation is a routine Terry stop involving Officer Phillips. I'm not aware of any case since Abbasi, certainly not in this circuit, where this court has found and upheld a Bivens case in a Terry stop or in a welfare check with a car on the side of the road.
Okay, but Mr. Parent, does it matter that the jury found that it wasn't a Terry stop by Officer Phillips?
As far as the Abbasi argument, I would submit that it does not matter. I don't.
Why not? Why not?
Because the issue that we're facing is whether or not an Article III court, in light of Egbert, could have even heard this case. Is this a viable cause of action, given everything we've just described, that it even shouldn't have gotten to the jury in the first place?
Yeah, but I still haven't heard you tell me any authority that talks about a lesser degree of intrusion being a meaningful context that we have to recognize in denying a Bivens remedy. You know, you're talking about how it's different, how it wasn't as egregious. No question, it wasn't as egregious as Bivens. But where is the case law that talks about the degree of intrusion being lesser is a factor? I don't see it in Abbasi. I don't see it in these other discussions.
Well, I'm out of time. If I may answer this question, and then I'll reserve the rest of my time. I actually would suggest that this court turn to the language as it's evolved in Egbert itself, because it does stress that the judicial guidance can be, and whether there's different judicial guidance can be and can create a new context if it is meaningful. If it was a situation that was identical to what happened to Webster Bivens, he's in his home, 6 ICE officers come in and ransack it, that's one thing.
Like again, I mean, like today is a seamless web. The law is amazing. You keep emphasizing 6 people they ransacked, and I think this just keeps going back to Judge Keenan's question. Like, there's nothing in any of these cases that says we look at how bad it was.
I'm not suggesting that you do, but what I'm suggesting is it's not so much the 6, it's the home. It's that they went into his home without a warrant versus when he's on the side of the road being approached on a welfare check that goes sideways. And whether there is any guidance here, I just think that is under these facts and under this progeny of cases, that is enough of a meaningful difference, because the Fourth Amendment rights involved and the privacy rights involved that could give rise to a Bivens claim are completely different.
So did you make this argument in the district court? Remember, you've been up here once before.
We made this argument in our Rule 50 argument, which is in the transcript. We did describe that there was a difference between this being home and car. I'm almost positive that we did. I will look and see if I can find the case site where we make that argument. But we made the Abbasi argument during our Rule 50, both at the beginning, at the end of our case, at the end of all evidence. So we do believe it is preserved. Okay. Thank you, Your Honors.
Good morning, Your Honors. My name is Yang Wu, and I represent the appellee Nathaniel Hicks. This is a case about line-level law enforcement agents engaging in routine law enforcement actions that violated a citizen's Fourth Amendment right to against unreasonable seizures. The particulars of this case involve actually 2 separate unlawful incidents. Seizures over one morning, seizures of my client, Nathaniel Hicks, which involved malicious and wanton behavior by the Park Police defendants, where the defendants continuously cursed at him, taunted him, threatened him, held him even though they knew they had no basis to do so, let him go only to start over the whole thing again. I'm going to get to Egbert in a moment, but I first just want to make 2 points. The first is, Before this case went to trial, it had the benefit of several comprehensive legal opinions about the core legal issues at stake, including one decision on interlocutory appeal by the Fourth Circuit and several opinions by Judge Grimm as well. And two, with the benefit of that legal framework, the jury rendered a verdict and found on every dimension in favor of Mr. Hicks. Turning to Egbert, Egbert does not affect this case's outcome. Egbert held that Bivens' claims remain cognizable. In Egbert, the Ninth Circuit had acknowledged that the case was an extension of Bivens because the defendants were Border Patrol agents. It had to do so given the Supreme Court's prior case law on Border Patrol. But under Egbert, Bivens' replays remain cognizable. And that's what we have here.
About what I see as you've read all the Bivens cases, right? You know what we're talking about. So if we talk about a different context, we have to have a different context. Okay, so why isn't the home a different context than the car?
Your Honor, there are several reasons why the home is not. It is a difference that is not meaningful, and that's our position, and that's what the law is here. First,
so there's law. Let's just take it out of Bivens altogether. There's law that says that you have the same rights of privacy and protection in the home as you do in the car. The home isn't the sacred place. See, I thought that was pretty well established too.
Well, Your Honor, the issue, and I think this is one thing that we do agree with here, is that this case has never been about the initial encounter, how you got there. And so the case is at some point very soon after the initial encounter, the park police officers knew they had no basis to hold him anymore, and then they continued to hold him. Whether he was held in that second part, whether he was held in his car or in his home, there is no issue of privacy here. Privacy would only be, the considerations of privacy are irrelevant to Mr. Hicks's constitutional claims. And to answer your question, yes.
I want to stop on the privacy point because now I'm confused just as a matter of Fourth Amendment law. I think you have different privacy rights in your home and in your car, but that goes to search cases. Right. I mean, this is a seizure case. I'm not sure that your seizure rights are different depending on where you're standing.
Thank you, Judge Harris. That is what I'm trying to say. In the seizure context, there is no difference in the law between if you are seized sitting in your home with no basis for doing so versus in your car.
In your home, you will also have a search claim because they came into your home. But if your claim is the seizure, it doesn't matter. I will figure this out. Okay.
Judge Harris, you're correct, and I'm sorry if I misconstrued it. There's been a lot of talk, and I know this also has to do with the prior argument about what constitutes a meaningful difference.
But can we just go back, because I think that's a fair point, but what we're looking at is different context. So maybe it's not a different context. I will take you, and especially my colleagues' suggestion that the seizure in the home, that it may be the same, but it is different. I mean, the outcome might be the same, but they are different contexts, aren't they?
Your Honor, there is a difference, but it is not meaningful. And if you'll allow me to define what meaningful means here,
this is meaningful for Bivens purposes.
Correct. It is not a meaningful difference for Bivens purposes. Just recently in Tate, the court drew a line and it said that to decide whether or not something is a fact is meaningful under Bivens, it's whether the fact implicates separation of power considerations. That's 54 F 4th at 846. And that is confirmed if you go back to Abbasi, which of course Abbasi is the ruling precedent on this first analysis, right? Bivens extension versus Bivens replay. And if you look at the 6 factors, of course, Abbasi doesn't say that this is the exhaustive list of factors, but the 6 factors that they spell out are informative because they go to why, if you drill down on them, they tell you why it is meaningful. And it's the same idea. These 6 factors are meaningful because they implicate or they would suggest some sort of additional intrusion by the judiciary into Congress or into the executive. And here we just don't have that. If we now look at the difference between Mr. Hicks being seized in his home, in his car versus Webster Bivens being seized in his home, there is no separation of power consideration that's implicated there, right? You still have a line, you still have the same line level law enforcement officer. The facts of the case are a normal seizure case that this judiciary is very well versed to do. You deal with it all the time in 1983 cases. You've also dealt with the Fourth Amendment car cases already in the past. There's Schulte, the interlocutory appeal decision cites that. So the judiciary has and continues to be well positioned to deal with car cases. And more importantly, there's nothing about, national security or immigration or anything that would suggest that Congress or the executive branch would be better capable, better suited to deal with a car case. And that is under Tate and under Abbasi, the relevant distinction about what is meaningful.
Counsel, do you have a view on what your sort of colleague on the other side is suggesting, which is that for purposes of the Bivens analysis or the Bivens question, we should act as though this jury trial never happened, because if they are right, it never should have happened. Can we take into account the jury's, given that it did happen, do we take into account what the jury found? And I'm thinking in particular of the absence of any policy. Can we take that into account? How do we deal with that?
Yes, Your Honor, you absolutely take into account. I think you would find on this case regardless, but you can take that into account. I think the understanding is, I think this is to suggest as though Egbert has made new law here.
No, I think what they're saying is, look, if we're right on Bivens, there never should have been a jury trial. So therefore, you have to answer whether we're right on Bivens without looking at the jury trial. At least that's how I understood the argument.
And Your Honor, they're not right on Bivens, so we'll start with that. I think I've not seen any case law that would suggest that this point in time argument they're making is accurate.
Well, except counsel.
They made the argument before you had the jury trial, right? This is the Bivens argument.
The appellants made the argument. Yes, so the procedure posture in this case is a little bit tricky.
No, I remember we had it once and came back and okay.
And it was a waiver issue on appeal, on interlocutory appeal. The court did find as part of their waiver decision, there was no fundamental prejudice to going back to trial on this issue. So it was raised for the first time in interlocutory appeal. We went down, we had a trial, and then it was raised at a Rule 50 motion, and then again here today. It was not raised at a motion to dismiss, though.
Okay, so counsel, why would you have the benefit of the jury's finding? It seems to me that you've got to analyze it in the pretrial context, and then you need to argue burden of proof in terms of establishing Bivens, don't you? Whether this is the Bivens case or not.
I've not seen case law, Your Honor, on whether it is a jury consideration of whether, of a Bivens extension. I've not seen that has to be part.
Right, but what Judge Harris is saying, and I think it's a really good point, is if the Bivens argument precludes a trial, which it would if it had gone against you, how can you then bootstrap your case by relying on the jury's findings? Don't you have to go back before there was a trial and argue the facts as they were then known? And if not, why not?
Your Honor, I would like to reserve some briefing on this because this was not raised. This was not raised for us, but just so I'm clear, at interlocutory appeal, that the issue was raised for the first time and the court found it was waived. That was not an issue from the appellee's position, right? And so
As it came to us, that wasn't a decision. You can never make the argument again. Right?
Right. And so here we are making the argument for the.
Let's make this
Yes.
really concrete. So I actually don't think that your colleague is really pressing this point now, but there was a time, and I think maybe it was when we first had this case, when a big part of the Bivens argument was this implicates official park police policy. And that's what makes it different from Bivens. We now know there is no policy. So on the one hand, it would strike me as somewhat odd to write an opinion saying that because this implicates non-existent policy, there's no Bivens cause of action. On the other hand, we know that there is no policy for sure. It was always disputed. But we now have resolution. We now know that there's no policy only because there was a jury trial. That should not have happened if this is an extension from Bivens. So in truth, like this is just giving me kind of a headache, like watching one of those
It's a little bit
time travel
circular.
movies.
I mean, we can answer
It
it
does
this way.
seem-
If this came up on a motion to dismiss, as it could have if it came to the motion to dismiss, then your honors would be examining it in the light most favorable to the plaintiff, right? So even though the defendants had some sort of defense that involved policy, I think your honors would say, well, that's a fact that you need to view in the light most favorable to the
I do
plaintiff.
believe that's what Judge Grimm said the first time. Like I can't call this a Bivens case based on a thing that there is a very genuine dispute as to whether or not it exists.
I think that's right. I don't think that Abbasi was actually in front of Judge Grimm, but I am sure he mentioned policy. I'm sorry.
Sorry, I was going to say this. Doesn't matter. Go ahead.
So if this had come in a motion to dismiss, then your honors would have approached this with the facts most favorable to the plaintiff. The fact that a defense from the defendants would not have given rise to you all, to your honors finding that fact in and of itself could give rise to a Bivens extension. So I think that's actually where we are, very, very far, many steps removed. But I think that's where we are here again today. You have you have to review the factual record in the light most favorable to the plaintiff here. And again, yes, just because the defendants raised a policy, that cannot in and of itself make this an interagency dispute. And
I'm sorry, I'm a little slow. I'm not sure where that gets us. If we do it in the light most favorable to you, then we send it back for another trial?
No, your honor.
Because you're telling us not to look at what happened at the trial. I mean,
I apologize. I do not mean to say to not look at the trial. What I'm saying is I think you're in the same posture where if you were to take the defendant's position and not consider the policy, then you would not be looking at this case as the jury had found them as in the light most favorable to the plaintiff. So at this stage, I see no case law saying that you would go back to the facts at summary judgment. I've now not seen case law to suggest a time warp that way. And certainly here where we are now, we have facts in front of us, including a policy finding. Your Honor, on the interagency dispute issue, though, I just to take a step back on that, there is no. This is another situation where appellants have construed the record in a way that favors them and not in the way that was actually found. There is no interagency dispute here. What you have, and they said this in their oral argument as well, simply comes down to the plaintiff happened to be a law enforcement agent. But as Judge Grimm said in his opinion, Mr. Hicks sued under his ordinary citizen's rights. And the only difference that his employment as a Secret Service agent made is that it made it more easily and more quickly confirmable that there was nothing that he was doing that rendered a basis for his continued detention. So when they say interagency dispute, that is a big packaged word that really means your honors should be considering the identity of the plaintiff as a law enforcement agency, as a law enforcement agent, as an independent reason to find that this case is different from Webster Bivens. And that's a dangerous line of inquiry, Your Honor. No other court has ever suggested that you look at the identity of the plaintiff to consider whether or not, the identity of the plaintiff matches that of Webster Bivens. And if we go back to Tate and we go back to Abbasi, it does not make sense. That would not strike a separation of powers consideration, and it would not be a meaningful distinction. I would also say that in that situation, I'm sorry, Judge Motz.
Go ahead.
I would also say that in that situation, you would run the risk of having everybody other than a federal law enforcement agent plaintiff be able to pursue a Bivens replay case. But for Mr. Hicks being a law enforcement agent, he would be able to pursue it. And so you would have a situation where somebody, by virtue of their federal employment, would not be given the benefit to pursue a Bivens replay case when everybody else will. And that I don't see any support for that in the law. I'm happy to go through the other factors of Abbasi. I'm also, happy to turn to qualified immunity if that's helpful for Your Honors.
This is sort of the thing that is getting me, is that the law was very different when we heard this the first time. And so it was perfectly, I think that what we did was entirely appropriate. If the law had been then as it is now, would you still say that it would be appropriate for us to do what we did?
Thank you, Your Honor. Yes, because when you say the law is very different then to now,
I'm talking about the Supreme Court.
You're talking about Egbert, I think. And Egbert, I just want to reinforce, Egbert cannot speak to the first question in front of us, Bivens replay versus extension question, because the Ninth Circuit there had already acknowledged that it was an extension. So the majority of Egbert, everything that's cited about, just one factor, it's all about assuming a Bivens extension, what special factors counseling hesitation would allow for that to be a new remedy. And here we're squarely in the first line. And for that, Egbert says nothing. Egbert does not have anything to say because it wasn't an issue because the Ninth Circuit did not raise it.
I do hear what you're saying about that, but the district court, I think, am I remembering this right, did go on to say, even if this is an extension, I don't see special factors counseling hesitation. And would you agree that Egbert does affect the step 2 analysis?
So Egbert has two holdings on the special factors analysis, and it says this catch-all of, if there's any reason to think that Congress is better situated, then you've got to go with Congress. So that is Egbert's holding on special factors, and I would submit that holding still has no impact on our case. The two special factors that Egbert focuses on are immigration, national security, border patrol, not relevant in our case. The second one is alternative remedies. Again, we've got the only alternative remedy here is a Secret Service inquiry into, whether or not Agent Hicks, performed it poorly in the line of duty. That's nowhere close to what Egbert had, which is a grievance process, years of inquiry in there. That's just not what we have here too. So there's national security, there is the alternative policy, and then this language of, is Congress better suited to do it? Or here it's not, right? And this is what we talk.
I thought there was a strain somewhere in these cases. If there's any reason to think that Congress would decide that the Congress rather than the courts should resolve this. Yes. I'm not sure. I don't think that an interagency conflict. I know that the players are from different agencies, right?
Yes, the players are from different agencies, Your Honor. And so
so maybe the federal government has a right to sort that all out, as it will, with whatever remedies it chooses to provide.
Yes, Your Honor, if this case was brought and somehow Mr. Hicks's identity as a Secret Service agent was part of his claim, I would
But see,
agree
the
with
thing
you.
is,
But
I-
here it was his ordinary citizens' rights. And I cannot emphasize this enough. If he had ordinary citizens' rights and his case is taken away from him because of his identity as a federal employee, that would be a strand of case law that certainly has not been seen either in the circuit or by the
No.
Supreme Court.
I don't think that's right. I mean, there are plenty of things that we can't do that you can do. I mean, like share our opinions with people. I mean, they're just, that's not true that there aren't, but I take your point here.
Yes, Your Honor. And my point is that when you walk out this door, you still have your ordinary citizen Fourth Amendment rights. And the suggestion here would be that you would not be able to assert your Fourth Amendment's ordinary citizens' rights by virtue of the fact that he was employed by the Secret Service. I'm very out of time, and I'm happy to answer questions on any of the other issues, or if Your Honors have any other questions for me.
Judge Keenan, do you have any questions?
No, thank you.
Thank you.
Thank you very much.
All right, thank you, Your Honors. First, Judge Mott's an administrative issue. I didn't give you the pinpoint site of our Rule 50 argument. It was Joint Appendix 319. So that's the part of the Joint Appendix where I make the Rule 50 argument on Abbasi, or at least began it for Judge Grimm. I do want to address a couple of points that came up in my learned colleague's argument. One, with regard to the issue of the hats that Agent Hicks may have worn at every one time. Certainly within the Bivens context, he's bringing this not in his official capacity, he's bringing it as an individual. But as I mentioned in our main argument, he actually wore both hats when he amended his complaint, because you don't get to a 1985 cause of action unless you're also a U.S. Secret Service agent. That's just one of those issues that I think creates a very different, unique circumstances that could potentially be a new context. Another new context, another stark one beyond the privacy issues, and it goes into this as well, is there's no search here. There was very clearly a seizure and a search in Bivens. There is no search here. He himself was never searched, he being Agent Hicks.
I don't see why that's a good fact for you, because if there was no search, I don't know why different privacy levels in the home and in the car make any difference. Those only go to your search rights.
Well,
I think if there had been a search and he was alleging a search, yes, the law as to searches in cars is very different than the law as to searches in homes.
But I was saying, I understand your point, Judge Harris, and I think that the broader picture, though, involved is the entire palpability of Fourth Amendment rights that Agent Hicks had at that time are starkly different. I don't think there can be any dispute about that. Search or not.
Right as to searches, if there was no search, seems irrelevant.
But there is no search here, and there was in Bivens. And in the context of the Abbasi analysis, that is, we believe, a crux of the issue. They're just completely different factual circumstances.
But Mr. Parent, they were a seizure of the person illegally, were they not in both cases?
Well, certainly with Webster Bivens, he was certainly seized. He got removed.
But it was in the case of Officer Hicks too. He was illegally seized, not at the inception when they made the welfare check, but once they knew he was a Secret Service agent, and then they go call the supervisor and detain him for another hour, not allowing him to get out of the vehicle. Why isn't that an unlawful seizure? Just, I mean, and again, it comes down to degree of intrusion. You seem to be suggesting, and I raised this question in the previous case, that the degree of intrusion makes a difference. In other words, because because he wasn't searched, he was only illegally detained, then it's not a Bivens case. Well, where is the authority in the Bivens line of cases that say a lesser degree of intrusion creates a new factual context?
I will cite again to the Mejia v. Miller case, which I understand is more instructive. It's not dispositive here, but I think that the analysis in light of Egbert is really key. I'm going to read this portion that I think Judge Keenan goes right to your case. More importantly, unlike Bivens, none of the events in question occurred in or near Mejia's home. The entire incident occurred on public lands managed by BLM and the National Park Service, a place where Mejia had no expectation of privacy. In Bivens, the unreasonable government intrusion occurred in his home. In short, Mejia's claim presents a new context, and given this new context, special factors counsel against implying a cause of action here. For example, a Fourth Amendment excessive force claims against BLM officers would have system-wide consequences for BLM's mandate to maintain order on federal lands, and uncertainty about these consequences provides a reason not to imply such a cause of action. And this cites Egbert at 1803 and 1804. And to sort of piggyback off of this claim with something that my counsel said in terms of the potential risk of how this could affect Bivens cases going forward. If this decision was allowed to be sustained and affirmed today, it could potentially open up Bivens claims to welfare checks on the side of the road and ordinary Terry stops. That is in direct contradiction to what the line of the cases beginning with Abbasi and then with Hernandez and then Egbert have been counseling against.
And I do totally understand that, but boy, the facts in this case are extremely unusual. And I hope, and I'm sure you're not suggesting otherwise. And I guess I have sort of a competing concern, like for now, Bivens is good law, and overturning this verdict and saying when this happens to people, they are detained for no reason, taunted, humiliated, frightened for an hour. You finally let them go, and then someone thinks it's funny to pull them over and do it again. And if we now, while Bivens is good law, have to say, oh, no, that's fine. That's good. There's no cause of action for that. I mean, I worry about the consequences of that as well.
I understand. And I would cite this, the Fourth Circuit's case in Bibbs actually has similar facts where there was taunting involved. And in that case, they found that Bivens could not lie. And I understand, Judge Harris, your concerns, but it does not.
Taunting doesn't, right.
I understand, but the end of the day is whether or not whatever it is the appellants did, does it give rise to a cause of action under Bivens? Is Bivens the cause of action that he can get redress from? Not an alternative remedy like the 1985 claim he brought, not some kind of remedy. There was actually an inquiry done within Secret Service. Agent Rattay testified to that, where he met with an Agent Christopher to figure out, they did a fact-finding mission, which indicates that at least within Secret Service, they looked at this. So I think given that, and I see that my time is up, if I could briefly conclude, unless the panel has any more questions. Given all that, given the uniqueness of this situation, that it does provide, in our estimation, a new context, and that there are several significant special factors that counsel against it, notwithstanding the jury verdict, the facts in this case bring Bivens into a new context that could have system-wide consequences for law enforcement. We respectfully request the panel reverse. Thank you very much for your time. Much appreciated.
Thank you both very much. We appreciate the assistance with this case. We are sorry we can't come down and shake hands, but we wish you the very best.
I'm good.
Right, then I think we'll go on to our third case. Number 27725, United States versus Troy.
My name is Jeremy Thompson. I am here on behalf of the appellant, David Troy. Despite a 121 to 151 month guidelines range, the district court denied Mr. Troy's First Step Act motion and left his 276-month sentence in place. That decision was neither procedurally nor substantively reasonable. I'd like to begin with the substantive reasonableness argument, given this court's recent order directing the parties to file supplemental memoranda regarding the impact of Concepcion, because I think that informs both in large part the substantive reasonableness argument, but also does have some impact on the procedural reasonableness argument. The parties agreed below and agreed before this court that the 121 to 151 month guideline range was what was applicable under this court's decision in Chambers and the retroactive career offender guideline range. The district court's order denying relief was not substantively reasonable for three main reasons. One, the district court could not rely alone on the original factors taken into consideration at sentencing. This court's decision in Swain makes that clear. Because the guideline range had significantly changed and the district court needed to justify its decision to leave a 276-month sentence in place that was within the original guideline range, given the new 121 to 151-month guideline range. Second, the district court must have distinguished the case from guidelines, from the run-of-the-mill guidelines range and guidelines case, and explain why this case was more significantly different and was not a run-of-the-mill guidelines case in order to justify its sentence. On that point in particular, I'd like to point out that the appellant below argued at page 136 of the joint appendix that if you look at the counterfactual situation where you do the guidelines for attempted murder, the sentencing range ends up not at 121 to 151, but ends up at 188 to 235. The district court's explanation for its saying when it says the district court's explanation when it said this was very nearly a murder case and that the 6th level enhancement, right, for bodily injury doesn't account for it, right? As that is at best, its best point when it tries to differentiate the case from the guidelines. It doesn't take into account the attempted murder guideline. It doesn't engage with the defendant's argument that attempted murder still would have a lesser guideline range. The district court said nothing about that in its argument. Sure, if it is attempted murder and the victim very nearly died, the guideline range is still significantly below the sentence that the district court ultimately left in place. And finally, the district court failed to give appropriate consideration to the remedial purpose of the First Step Act. It's particularly important in this case because the original guideline range of 235 to 293 months was driven by Mr. Troy's drug offense. His career offender enhancement was solely due to his drug charge. So the significant sentence that he ended up looking at was from his drug offense and from the fact that he had a prior drug offense. And the First Step Act was looking to alleviate those harsh sentences that associated with drug offenses.
Can you, I want to make sure I understand that part of your argument. When the guideline range was recalculated in this case, the entire decrease is a result of correcting for the Simmons error, right?
Yes.
Okay. So that does seem different from Swain to me, because I thought in Swain there, the difference had a lot to do with the actual new crack quantities in the Fair Sentencing Act. And there we were able to say, look, if you don't reduce it, you're kind of at odds with Congress's purpose in lowering those crack quantities. Whereas you don't really have that here because the reason it went down was because of the Simmons error, which is incredibly important, but is not part of the First Step Back Fair Sentencing Act. But you're saying, no, it all implicates the same policy because the Simmons error in turn traces back to a drug conviction in North Carolina?
Yes, that's part of it. And also the fact that the underlying career offender guideline range was driven solely by the drug offense, by Mr. Troy's federal drug offense. But also, as this court has recognized repeatedly, first and foremost in Worsing, but also in Chambers, one of the main reasons the Congress passed the First Step Act was to provide relief for defendants who were not eligible for Fair Sentencing Act relief, in large part because they were career offenders. So if the point of the First Step Act is to get the Fair Sentencing Act to individuals who were designated career offenders, then it's also part of the First Step Act.
Right, so it's part of the First Step. Okay, because everything you just said, I understand. We've said it in opinions. I was on the panel in Chambers. I totally understand that as a matter of just what is the right way to think about this. But I do have trouble reconciling it with Concepcion, which seems to me to say something different, which is that for benchmark purposes, you don't consider any of that. You may consider it after you've set the benchmark as a reason to grant a reduction. But you read Concepcion differently.
Well, yes, and I believe the government does as well in terms of calculating the benchmark guideline range. Concepcion was quite clear to use the word non-retroactive repeatedly, both in footnote 6 and in footnote 8. And Concepcion, I think, fully accords with Chambers and says that retroactive errors must be corrected. That is the whole point of the Fair Sentencing Act, the Fair Sentencing.
But Mr. Thompson, what, if I may, when you look at that footnote 6, it says that the district court cannot recalculate the benchmark guidelines range in any way other than to reflect the application of the Fair Sentencing Act. So, I mean, by saying in any other way, they seem to be absolutely closing the door on what you're saying. I understand you seem to be arguing the logic behind the First Step Act. And you're saying Congress wanted to help these people who were getting trapped in these career offender enhancements. And I understand that. But we've got this language from the Supreme Court that says courts can't recalculate the guidelines in any other way than to reflect application of the Fair Sentencing Act. So it seems to me we've got to find language in the act itself that points to the kind of relief that you're asking for. In other words, that you can still recalculate the guidelines if you have a prior drug conviction. I mean, I see the logic of what you're saying. I just don't see the authority for it.
Well, Your Honor, I think kind of the way to, I think there are kind of two ways to look at Concepcion and to look at footnote 6 as it relates to Chambers. And Chambers is holding about retroactive guideline ranges must be corrected. Either it says nothing about Chambers, right? Because the specific issue in Chambers was not before the Supreme Court of Concepcion, right? And so it says nothing about retroactive. It says nothing about other retroactive errors.
Can I just, I'm sorry, I don't want to stop you before you get to 2, but I struggle to read the opinion that way as a whole. It sure looks like the Supreme Court is just trying to explain how to do this thing, and that they are not trying to issue like a very fact-specific opinion. It appears that they are trying to finally explain how we're supposed to run these 404B proceedings.
I agree that is their intent. That is what they are attempting to do in the decision. But that I think the Supreme Court didn't put in anything regarding other retroactive errors in its decision because it didn't need to. It didn't have to. I think that was implied by its use of non-retroactive when describing things that the courts may consider. The footnote 6, the final sentence of footnote 6, is the district court may then consider post-sentencing conduct or non-retroactive changes in selecting or rejecting an appropriate sentence. Why would the Supreme Court have used the word non-retroactive guidelines changes? They would have just said guidelines changes. Non-retroactive specifies and clears, makes clear.
I think I don't know. I agree, like this whole thing could be a little bit clearer. I assume that that when it came to after you have sent the benchmark, there was no real dispute as to whether at that point a district court could take into account retroactive changes in deciding whether or not to grant a reduction. The dispute was over whether at that point the district court could look at non-retroactive changes. And so the court is clarifying, look, nothing but the actual drug quantity differences in setting the benchmark. But after that, non-retroactive, as well as sort of almost in brackets, as well as retroactive changes may be taken into effect because that's what was contested.
But I think looking at it and saying non-retroactive and retroactive guidelines errors, when you look at footnote 6, leads to the problem that I pointed out in the supplemental briefing, which is the other retroactive amendments that in particular regarding the drug levels that the Sentencing Commission has enacted other than the Fair Sentencing Act changes. After the Fair Sentencing Act's retroactive changes, there's another round of 2-level reductions. And I believe it's Amendment 7. I believe it's 768. I'll have I'll get the exact one momentarily. But there's a second round of retroactive guidelines changes by the Sentencing Commission. And so if you read this literally as the only thing that you can take into consideration that you must fix is the Fair Sentencing Act and the Fair Sentencing Act's amendments, then you cannot recalculate the guideline range in light of the subsequent 2-level reduction that the Sentencing Commission enacted. And that gets grouped in with the final sentence of footnote 6, which means that if a district court refuses to reduce the guideline range further beyond the Fair Sentencing Act, reads it literally and says, I cannot do anything other than the Fair Sentencing Act, then if the district court denies the motion, a defendant then has a right under under USSC 1B1.10 to file a second motion for a reduction in sentence based on the retroactive amendment that he didn't get the benefit of.
What about footnote 8? The First Step Act does not require district court to recalculate a movement's guidelines in any respect other than applying the Fair Sentencing Act.
And then it refers back to C note 6. So I look at that as restating what is in footnote 6.
But it seems to me that the problems that you saw in footnote 6 are not replicated in footnote 8. That it doesn't have,
but footnote 8
have this language that you relied on about retroactive.
It does. The first sentence is the dissent contends that permitting a district court to consider non-retroactive guidelines amendments will create a disparity between First Step Act eligible movements and other defendants. So it's talking again about non-retroactive guidelines amendments in footnote 8, just like it is in footnote 6.
But so, I mean, we never want to assume that the dissent is properly reading the majority opinion. There's all kinds of stuff going on, but I thought the way the dissent described what was going on in these footnotes seemed pretty sensible, a sensible reading. The court properly notes that district courts must begin a First Step Act proceeding by calculating the new guidelines range based solely on changes to the crack cocaine sentencing ranges. Isn't that basically what they're saying? Like, look, you can look at anything that has to do with changes to the crack cocaine sentencing ranges, but not things like our decision in Simmons.
I don't, well, and again, Your Honor, like you're saying, that is the dissent reading the majority opinion, but I think the dissent also talks about, the dissent also talks about non-retroactive changes. The dissent talks about non-retroactive changes to the guideline range based on career offender. And I see I'm out of time, if I may if I may finish responding. I think the dissent is drawing on the same differences between retroactive and non-retroactive changes that the majority opinion is addressing. And obviously, I wish the majority opinion were clearer on the distinction between non-retroactive and retroactive changes. But certainly, we would submit that that footnote 6 doesn't close the door to Chambers. It does not abrogate Chambers. And with that, I'll reserve the rest of my time.
May it please the court. My name is Amy Bauer and I represent the United States. The district court did not abuse its discretion when it did not reduce Mr. Troy's sentence under the First Step Act because its decision was both procedurally and substantively reasonable. As a result, the district court's order should be affirmed. And Your Honors, I would like to start my argument with the questions you raised to the appellant as it relates to Concepcion's effect on this court's precedent and specifically the Chamber's opinion, whether retroactive and or non-retroactive, if there's a difference based on footnote 6 and then Concepcion holding. And I would note for Your Honors that the government took the position it took in its supplemental brief in this case that the guidelines were appropriately recalculated by the district court based on this court's precedent in Chambers because of its precedent in Chambers. It's for this court to decide whether its Chambers precedent is no longer good law based on Concepcion. And I would represent to Your Honors that in any other circuit around the country, the Department of Justice takes the position that the benchmark guidelines as referenced in footnote 6.
But I don't understand that at all. Concepcion means whatever it means. What is the government's position as to what Concepcion requires? When the district court calculates the benchmark, what is the district court supposed to do in a 404B proceeding under Concepcion?
Yes, Your Honor. And I believe when you read Concepcion, what a district court is supposed to do is to look at how the guidelines would be different as if the Fair Sentencing Act were in place in the First Step Act gave that retroactive effect. So a benchmark guidelines, as Your Honor appropriately noted in the beginning, the appellant's benchmark guidelines did not change in this case. His guidelines were driven by the cocaine, not the crack, which created the disparity that the Fair Sentencing Act was aimed to resolve. And so the government's position, and the reason I believe the retroactive question is important is because in this court's precedent in Chambers took the position that retroactive changes in the law, so in this case a Simmons error, had to be accounted by a district court when it was recalculating the guidelines in a First Step Act resentencing.
Does the government think that can be reconciled with Concepcion or not? I don't understand the idea that the government's position would be based on our circuit precedent if there is intervening Supreme Court precedent that the government thinks renders our circuit precedent superseded.
Your Honor, the government would argue that it can't be reconciled with Concepcion if you read it literally. In the majority's opinion,
how would you read it?
I think you would read it that when you recalculate the benchmark guidelines, that you only can look at the retroactive changes that the Fair Sentencing Act would have implemented. And here, there were, as the amended sentencing report pointed, there were no changes to Mr. Troy's guidelines when you took into the retroactive considerations of the Fair Sentencing Act. And so then, though, I think how you would read Concepcion, Your Honors, is it clearly states that a district court, once those benchmark guidelines are calculated, may consider intervening changes in the law. So in this case, a retroactive change or a non-retroactive change, and exercising its discretion on whether or not to reduce a sentence under the First Step Act.
But this isn't the argument you made in your brief, right?
Yes, Your Honor, it's not. And Your Honor, I would note.
No, it's not. Or I'm correct. You didn't make it in your brief.
I did not, Your Honor. And we did not make it in our brief based on this circuit's precedent in Chambers.
But if we send, I will let this drop in a minute. We know our precedent in Chambers. If we send you a letter saying hey, does Concepcion have any bearing on this? We are actually looking for the government to tell us, as we read Concepcion, is your precedent still good or not? And I am somewhat confused that, I mean, I thought you were conceding this in your brief.
Your Honor, we conceded it based on Chambers. And, I certainly understand what your honors are saying is that you asked us to not make the concession if we didn't agree that Chambers was still good law. But and the Department of Justice takes the position that in any other circuit without the Chambers opinion, that the benchmark guidelines calculation would only be looking at any changes that were made retroactive by the First Step Act's, the Fair Sentencing Act.
So, okay, I don't have your response in front of me, but did you say that in the response? I thought you just straight up agreed with them.
Your Honor, and we did agree with what we did agree, as Mr. Troy's counsel argued, that because of Chambers and this court's precedent, that a retroactive change in the law would need to be considered when recalculating the benchmark guidelines in a First Step Act proceeding.
What this means, it's not what it says. It says, first of all, the district court correctly took retroactive changes in the law into account. And then it says Concepcion doesn't address the question. It doesn't address whether a district court must account for retroactive changes in intervening case law. I understand what your position is today, but it just would have been helpful to have that in advance.
Yes, Your Honor, and I certainly understand. And so if Concepcion, and I think you referenced the dissent earlier when the appellant was making his argument that you just look at the benchmark guidelines and then you can go further and decide, a district court can go further and decide whether in its discretion it feels like a sentence should be reduced based on intervening changes in the law. And Your Honors, I would move to the next point of my argument is.
Well, before you do that, can you give us your views, the United States views on whether you waived this argument that you're now making?
Your Honor, obviously it's been raised in the briefs, and I think that,
I thought that my colleague just looked at the brief and didn't see it. So maybe you could.
Whether I raised the argument that, I'm sorry, I apologize. I thought you meant whether I raised the argument to change, the position I'm making today. I apologize, Judge Motz. I think that it is this court today, and ordering oral argument in this case, we have to look at what effect Concepcion may have on this court's precedent. I think we can all agree, had Concepcion not been decided, Chambers would be what we are looking at today.
We address this in light of Concepcion?
I'm sorry, can you repeat the question?
What was the question that we asked you to address?
You asked us to address whether Concepcion's holding has an effect on the benchmark guidelines.
Right. And so you're now saying to us, yes, it does. But you answered us, no, it doesn't. So have you waived that argument?
Your Honor, I think that, from a waiver perspective, it would be for this court to decide, and certainly we cannot have precedent that is in contradiction of Supreme Court precedent. But I would raise the point that if I have waived the argument, and if this court determines that Concepcion is not in conflict with the Chambers decision, that retroactive decisions in the law must be considered.
Do we even have to reach the question? At least in front of us, we have two parties, at least on the briefs. Parties came to the same answer. Concepcion does not affect this. The benchmark was correctly decided in this case. Can we just say, look, parties agree, this is the correct benchmark?
Your Honor, I think you could, based on the circuit's precedent, and then we would go to the next question.
Not based on the circuit's precedent, based on the arguments. In their briefs, agree that under Concepcion, this is the correct benchmark.
Correct. And so if we move on to the next analysis, it's whether the decision was procedurally and substantively reasonable to retain the original sentence in light of what the recalculated guidelines were. And it's the government's position, Your Honors, that it was both procedurally and substantively reasonable. Your Honor,
okay, I just want to be sure I understand so that we can take what you've said in your brief. We don't have any obligation to read the law ourselves, notwithstanding your concession.
No, Your Honor, I do think there is an
But you
obligation.
didn't tell us about that first time when my colleague asked you either, right?
Yes.
So
Your
do
Honor.
we have some sort of independent obligation to find out what Concepcion does or doesn't do?
Your Honor, I would ask for, I'm not quite prepared to address that based on the circuit's precedent today. But what I would like to make sure that I do raise is if this court finds it is not obligated to address that, and then the issue has been waived based on the parties' agreement, we still look to see whether the district court's order was procedurally and substantively reasonable. And here, from a procedural reasonableness perspective, it was. If we assume the guidelines were properly corrected, then a district court must analyze the 3553A factors and consider Mr. Troy's.
The bigger problem is with substantive reasonableness, don't you?
Yes, I agree, Your Honor. And then as Judge Harris mentioned, the Swain opinion, that really focused on the remedial context of the First Steps Act and retaining a sentence with that large of a variance was substantively unreasonable. I would note that the district court in this case did put the parties on notice that it was considering an upward variance, and it allowed further briefing on the issue. And then in its order, it addressed specifically why it felt like retaining the original sentence was appropriate in light of Mr. Troy's specific individualized characteristics. And I think what Concepcion does is it directs that a district court has great discretion to choose whether to reduce or not reduce a sentence under the First Step Act. And here, the remedial purpose of the First Step Act was to reduce the disparity between crack cocaine and powder cocaine offenses. And here, there was no reduction in Mr. Troy's guidelines under the First Step Act. And so when the district court was considering his arguments, he looked at the 3553A factors. It's the government's position that Mr. Troy did not introduce any evidence that was not available to the district court at the original sentencing. But it did consider the non-frivolous arguments that were raised by Mr. Troy. And then when it determined not to reduce the sentence, it was substantively reasonable. And, as this circuit's precedent does establish, what has to be done in a district court level is to give this court an opportunity to conduct a meaningful appellate review. And when we look at the joint appendix in this case, beginning on page 143, the district court listed the 12 arguments that Mr. Troy had raised and to support his position why a sentence reduction was appropriate. And then it also specifically mentioned that it considered the age of his offense, that he was 17 at the time of his North Carolina conviction, and said that the district court did not find that persuasive. And then it further went on, as this court's well aware, the nature and circumstances of the offense is one of the 3553A factors that must be considered. And the district court spent 4 pages addressing why a reduced sentence was not appropriate. And so we believe, when you look at the record as a whole, that the district court has given this court the opportunity to conduct a meaningful appellate review to make a determination that its sentence was substantively reasonable.
Judge Keenan, do you have any questions?
No, thank you.
Thank you, Your Honors.
Thank you.
Excuse me, it was Amendment 782. That was the second retroactive amendment. And I would note that both the government and I cited to the Eighth Circuit's decision in Shepherd, which said that the district court, which is post-Concepcion, said the district court properly disregarded or properly did not incorporate non-retroactive changes, but properly included 782's retroactive change in calculating the guideline range. And that was a case that was specifically concerned about how the guidelines were properly calculated. I think
the Third Circuit has since then in the Shields case, I think, come out the other way. So I feel like the case law on this is a bit emerging and
Yes.
mixed. Yeah.
And I think it will continue to be seen. I'm not certain off the top of my head if the Third Circuit, and this only does pertain, I think, to the substantive reasonableness side of things. If the Third Circuit is one of the circuits that has applied substantive and procedural reasonableness to First Step Act claims, which I do believe is required by Concepcion. But in looking at maybe a different way to look at what the First Step Act did and what in incorporating the Fair Sentencing Act. The First Step Act, the text, as your honors were asking about the text, how do we ground this in the text of the First Step Act? The First Step Act tells the district court to proceed as if the Fair Sentencing Act was in place. That requires the district court to go back in time and pretend like it's back in 2011 or 2012 or whatever after the Fair Sentencing Act.
I understand that. Why doesn't it just tell the district court, you're in whatever year you're in? We're having a lot of time travel this time. You're in whatever year it is currently, but act like the First Sentencing Act.
If I wish the First Step Act were better written. I mean, this court found in Chambers that the 3553A factors applied to First Step Act decisions, and that's not in the text of the First Step Act either. The Supreme Court in Concepcion found that the First Step Act requires that you apply the guidelines amendments passed by the Fair Sentencing Act or passed after the Fair Sentencing Act, but that's not in the text of the First Step Act either, right? That is something that the Supreme Court decided was congressional intent, but that's not in the text of the First Step Act either.
Well, the First Step Act was a product of the Fair Sentencing Act, right?
Yes.
A follow-up.
A fix.
So that's a fair.
Yes. And so I think by putting yourself in the position, district court, putting yourself in the position as if the Fair Sentencing Act had been in place at the time when you originally imposed a sentence, you're looking at what was retroactively the law at the time of the sentencing. And retroactively, Mr. Troy's career offender guideline error was an error at the time. That's what the difference between retroactive and non-retroactive was. So if the district court put itself in the position as if the Fair Sentencing Act applied when it originally posed a sentence, Mr. Troy's career offender designation was also unlawful at that time. And so that's the jurisdictional hook that this court can use to say the First Step Act makes the Fair Sentencing Act and makes all retroactive changes apply at the time the district court makes its decision. I do believe, Your Honor, based and obviously I began my argument by saying the government, I agree. I believe this court can write this decision without having to get into this morass, given that the government agreed in its briefing before this court can simply say the parties agree based on that stipulation, 121 to 151 months is the appropriate resolution. We can leave what Concepcion does to Chambers for another day because it hasn't been argued, hasn't been presented. No party has argued before this court except briefly today that Concepcion changed Chambers or abrogated Chambers in any way. And so this court can proceed from the assumption that 121 to 151 is appropriate given the government's concession and then review that decision for substantive reasonableness. And we believe, given what this court did in Swain and the factors that this court found particularly relevant in Swain about not giving credence to the First Step Act's remedial purposes, about not differentiating the case, taking just the original sentencing factors that were taken into consideration.
Counsel, can I just ask you about that, sort of assuming that this is now a massive variance, just assume for purposes of this question, that's the world we're in. I mean, I thought the district court did a pretty good job. I understand this is substantive, not procedural, but we do look at how the district court justified it. It's not, given that what has dropped the guideline range is a Simmons error, and again, understanding the importance of career offender designation and the Simmons issue, it's not I'm not sure it's unreasonable for a court to say, look, based on what happened here, the attempted murder and everything, you know, the fact that it turns out that because you didn't serve the right amount of time on that drug offense from a million years ago, you're no longer a career offender. It just doesn't change the way I look at the 3553A factors here. You did everything I thought you did. You know, nothing about your conduct has changed. Not the past offenses, not the current offenses. The only thing that's changed is whether the amount of time you did on this North Carolina drug conviction catapulted you into career offender status, but everything you did is the same. And so I'm not changing my mind under 3553A. How is that substantively unreasonable?
Your Honor, I see I'm out of time. If I may respond, this court was presented with that almost exact same factual scenario in Swain.
Except for, I do think it's a key difference that there the range went way down because the drug quantities changed exactly as anticipated by the First Step Act, Fair Sentencing Act. And we said that was the main problem. Like you are just running headlong into Congress's intent that because your quantity went down, you're not supposed to be punished as severely, but we don't have that here.
But what we do have is we have a situation where a district court not only left a variance, and again, the justification needs to be the more you go above the guideline range, the better the justification has to be. And here, the justification is what I took into account at the original sentencing still stands. All right, that's not sufficient. And then when you look at the significant degree to which the district court upward varied, because you have to go all the way up to the pre-departure range because the judge says, I would have imposed the same sentence on anybody who had committed the same conduct. That means that you're looking at almost 400 months as a benchmark for an attempted murder offense. That's the import of the district court's finding, is that I would have given anybody this sentence and you only get to 276 because you cooperated against corrupt cops. And so he's saying any attempted murder is 400 months. And that's not what the guidelines say. The guidelines start attempted murder at 33 and you can get up to 37 for the offense conduct itself. So the district court not only had to justify going to 276, the district court had to justify going all the way up to 400 and then back down to 276 based on an attempted murder, and the district court makes no effort to say why this case is different, more distinctive than any attempted murder, because any attempted murder by its very nature is going to have terrible factual facts where someone almost died. And those defendants aren't sentenced to 400 months in prison. And they're not even sentenced to 276 months in prison. They're sentenced to 15 years in prison. That's not the sentence he was serving.
No, I'm sorry.
Judge Keenan, do you have questions?
No, thanks.
Thank you very much.
Thank you.
Thank both of you for helping us today. We're sorry we can't come down and shake hands. We wish you the best. (224049) United States versus Vladimirov.
Pardon me, Your Honor, I'm having
Yes, sure, when you're ready.
difficulties on the
Doing the same thing.
I'm like sealed together.
That fourth part here. I've got an extra one if you need it, Eric.
I think you're.
How many lawyers does it take?
Efficacy was handling the other one, but anyway.
Yes, thank you, Mr. Weston.
May it please the court. My name is Rich Weston. I'm here on behalf of the appellant, Nedelcho Vladimirov. Thank you for giving me the opportunity to come here and have a discussion about the case. We're asking that you overturn his convictions for money laundering and money laundering conspiracy. One of the bedrock principles of any proper jurisprudence system is that a defendant has the right to confront the accusers against them. Our Supreme Court tells us that there is something deep in our human nature that regards face-to-face confrontation as essential to a fair criminal trial.
But that's what it's about. I don't see why having a mask on stops that face-to-face confrontation. Like, I agree with you that that is sort of the bedrock principle under the confrontation clause, look me in the eye and say that, but that happened here.
Well, Your Honor, the one good quote from Rivera versus State, which is the Texas case, says that the most expressive part of the body and something that is traditionally regarded as one of the most important factors in assessing credibility.
But assessing credibility is different. I'm sorry. I thought you were starting at least with the bedrock principle behind the confrontation clause, which is not credibility. I mean, in court, it's what you said. It's the confrontation between the witness and the defendant. If you're going to testify against the defendant, then you do it in person and you look him in the eye.
And I think that
We
goes
have that here, right?
I disagree, Your Honor. There are 4 reliability factors.
You started your argument with this bedrock principle. You need a confrontation between the defendant and the witness. We had that. There may be other things you want to talk about credibility and reliability, but as to if you're going to testify against this guy, you do it in front of him. That happened, right?
We superficially had physical presence. I believe you're correct about that, Your Honor.
What was superficial about it?
Well, I believe in the Romero case talks about that. The whole thing is this face-to-face is that their face is uncovered, that you're able to interpret everything about them, that it's not there though when their face is covered. I mean, even though they're physically present, the 4 factors that are reliable, the 4 factors I think that are the core concerns of the confrontation clause: physical presence.
Excuse me, though, Mr. Weston, before you get into your merits argument, how was a constitutional objection preserved in this case? I realize you weren't trial counsel, Mr. LaFawn was, but he simply said to the court, the credibility of the witnesses are going to be very important for this case. My concern is that the witnesses and lawyers are being masked during questioning. So I'd move the court to allow the witnesses to be able to proceed without masks. Now, how is that a constitutional argument? I mean, and I'm wondering specifically, how does the court, the district court, know that a constitutional argument is being made? Because if one's being made, then the court had to make findings, did it not, as to an important public policy and reliability? So if you'd address the preservation argument first, please.
Yes, Your Honor. And that wasn't raised in the briefing, but I will address that to the best of my ability. I believe you pointed out he used the word credibility, and I believe he also used the word demeanor in his statement to them. It was used by either him or Mr. Goes. And that is one of the 4 pillars. And I know you want me to get to this, but I think I have to say that the 4 pillars are physical presence, oath, the observation of demeanor, and cross-examination. And in this case, I think by using the words credibility, by using the words demeanor, that is obviously implicating the confrontation clause of the 6th Amendment.
But you see, the whole discussion of this issue before the district court was both sides saying, oh, we would prefer to do this and we would prefer to do that, and we prefer not to be masked ourselves, and we prefer not to have the witnesses. But there was no, it seems to me, argument to the court that you must do this to comply with the Constitution or anything else.
Yeah, I'm not aware of any specific law that requires a must that you have to do this.
No,
There are many, many cases that say, and right in this context, like if someone objects on hearsay grounds to testimony, saying it's not reliable. The district court overrules that. That's not enough to preserve an actual confrontation clause claim. Like, you really have to say, this is not a regular matter of court discretion. This is a constitutional claim, because otherwise district courts don't know.
I think it's obvious from the context here.
I think it's obvious from the context that everybody thought it was within her discretion. That's the problem with your argument.
And to back up just a minute, Your Honor, I don't even know where this rule came from. It's not clear from the record. I don't know if it was thrown upon them that day, which wouldn't have given him much opportunity to address that, because
What you don't know what rule it came from? What are you talking about?
about the witnesses being required to wear masks, because that was not let's back up a little bit. There was a standing order at the time, a standing order that the presiding chief judge had entered, Judge Johnston, and it did not require the witnesses to wear masks at this time, because this case is not during the.
No, a week later, though, that he reissued the standing order, right?
I don't recall, but I have no reason to.
And then you take it from me that that's what happened.
I have no reason to
I
dispute
mean, that's in the
that.
record.
Yes, but what I'm getting at is, Your Honor, is that the standing order that was in effect at the time of this case said nothing about witnesses having to wear masks. So apparently it was communicated at some point to counsel that the witnesses were going to be required to wear masks. But I don't see anywhere in the record where that ruling was made to the judge. What I see is just this colloquy right before trial where the lawyers brought up the issue and said that the credibility and the demeanor of these, especially these four witnesses who might be on drugs and who were crucial to this case, were going to be required to wear masks. So I believe it was apparent from the context and that was thrust upon counsel, and it wasn't, something that was a standing rule that he knew he would have to encounter before trial.
Well, you acknowledge you had to make the argument, and you had to let the district court know that this was a constitutional argument, right?
Again, that wasn't briefed, Your Honor. I'm not too on. I think it could be the context.
You're the one it's appealing, so you're the one that should be briefing it.
Well, I believe that it was apparent from the context, Your Honor, that this.
What was apparent from the context?
That this was a constitutional argument because he specifically said credibility and demeanor, and that
credibility and demeanor are often evidence questions, right?
Well, I think in the context of the confrontation clause, demeanor is one of the four pillars, and then it's implicated. Now, the government doesn't appear to dispute that wearing these masks was an infringement of the text of the Sixth Amendment. I fully believe it affected the ability to assess the demeanor, not only for the jury. I believe it also affected the cross-examination. Some of my best cross-examinations done when a witness says one thing, but their face tells me another thing. And by a mask covering a large part of the face, I believe that was affected also.
I mean, the courts are kind of split on this, right? There are a lot of courts out there saying it really doesn't implicate any of that because whatever, you can't see their nose. You probably weren't reading that much into how they move their nose. It does hide the mouth. But you've still got the eyes, you've still got body language, you've still got tone of voice, you've got enough demeanor cues that this is really just de minimis and it doesn't make any difference.
I would disagree, Your Honor. And some of this goes back to the court never made any findings on why they would have to wear masks. I think these are the questions that would have been answered by the court had it been properly considered.
Well, isn't that circular though? Because the court didn't make findings because you didn't raise trial counsel didn't say it was a constitutional argument, which would then obligate the court to make findings regarding important public policy and reliability.
I agree there is some circularity to it, but I just do not admit that it was waived somehow because he didn't say the magic talismanic word confrontation clause.
So I guess, and I'm suggesting even a separate problem, which is assume you had raised the constitutional argument. The courts appear to be divided on whether that would have obliged the district court to make findings, because if it doesn't implicate the confrontation clause, district court doesn't have to make the findings. And there are a lot of courts out there, both pre-COVID when they're talking about other facial coverings and post-COVID talking about masks, saying it just doesn't implicate the confrontation clause. It's not a big enough deal to make a difference to any of the underlying purposes of the confrontation clause?
Well, I don't know exactly. They've cited a bunch of district court cases, but that takes me back to Coy versus Iowa. Coy versus Iowa was the case that was authored by Judge Scalia, where they put it was some type of screen up, and they could still, he was right there. They could still, the only thing was the kids couldn't see the defendant in that case.
Right. What's interesting about that case is there was no effect on, it had nothing to do with credibility, juries making credibility findings. The jury had a perfectly good view. The only thing they cared about was that you lost the face-to-face confrontation between the defendant and the witness, which again, we did have here.
And we didn't know I think we didn't have a proper cross-examination on the pillars. I think when there was not, I think it affected the ability to observe demeanor. I think Coy is also talking about these 4 factors that I'm talking about. And if it's
Why are you talking about the jury's ability to view demeanor? The jury was looking directly at the child witness. There was no screen.
Well, in that case, it would have been the defendants, but at least somebody who is I don't know what you would call them, a core component was not available to do that in that case. But, and that kind of goes to whether Crawford, even the Coy and the Craig line of reasoning is even valid anymore after Crawford, with these reliability determinations by the judge, which essentially what that is you're saying this was still reliable, even though there was a slight infringement of demeanor. Is Crawford tells us we don't, unless it's if it's a testimonial statement, unless it is a historical exception to the confrontation clause, then nothing can apply.
That's over our pay grade. I totally take your point that, who knows where the Supreme Court will go on cases like Craig. But for now, here we are. And I guess I would just say, I think the courts are divided on this. And I will just tell you, my concern is, I take your point, like something covering even a part of a face. You could argue, of course, that at least affects the confrontation, right? But I do sort of worry about the slippery slope here. I'm just trying to think of hypothetical, somebody who has a sore throat, like you can't really understand the timbre of their voice the way you normally would be able to. Someone who uses Botox, you can't really get as much out of their face as you would like. I mean, there's, at some point, we call these things de minimis, I think. And I think figuring out where to draw that line is actually quite difficult.
Yeah, I agree with you on that, Your Honor. I've wrestled in my head with those questions a lot. There's one Ninth Circuit case. I don't think it's cited anything. It's maybe Jesus Castaneda, but a witness in that case wore, I believe, a wig and a mustache. And in that case, I think they're probably right there that, because a person might naturally have long hair, might have a mustache. In that case, I understand what they're saying there. But these masks that we're wearing, they cover the majority of your face. Our faces are so expressive. Y'all are judging my demeanor probably right now by my face. So, this is the confrontation clause, the 6th Amendment. I don't think, even if it is a slight, or a lesser infringement, it's the confrontation clause. And we have to fully preserve that for a jury trial for them to see that, I believe. And I believe that the lawyers have to see that. I believe that everybody has to be able to see that. And, even it's not a confrontation clause issue, but even my client now, the defendant testified and he had a mask on his face. They didn't get to see that in this case. I just believe that this case, I understand you disagree on whether it was preserved as a constitutional claim. But in Coy, they said, since there have been no individualized findings that these particular witnesses needed special protection, the judgment cannot be sustained by any conceivable exception. And I believe that makes your job easy in this case.
Bet you thought you were going to be arguing different issues.
I'm ready to go wherever the court takes me.
Your brief.
May it please the court. Eric Goes on behalf of the United States of America. Vladimirov's guilty verdict should be affirmed. Let's turn first to the face masks issue. It was our position in the brief, and as correctly stated, the use of the face masks do not violate the confrontation clause. We did walk through the Maryland versus Craig 4-part balancing test, as has been alluded to, but pre-trial, and this issue was raised the weekend, or excuse me, we picked a jury on Friday. We started the trial on Monday, so it was raised in advance by the court. So the court gave us specific instructions as to how she wanted the courtroom to be operated. It was raised as an issue. It was not couched in constitutional terms in the
Is
record.
the transcript that we have of that discussion, is that what you're talking about? Did that take place pre-trial?
Yes, Your Honor.
Okay.
And that's JA 450 to 451, just so I had it handy and I wanted to double check. Now, Judge Berger did do a balancing test with regard to that, which kind of has echoes of the Maryland versus Craig test. But
There are Craig findings. You're saying the judge made the findings that would be required under Craig in this case?
No, Your Honor, I'm not. I'm suggesting that they were echoed. That is to say, she did a risk analysis based on the public policy against the effect of masks on that. And that's.
So can I just ask you, I couldn't tell from your brief, like assume hypothetically this issue is properly raised or for whatever reason we are plowing ahead and reaching it. What is the government's position on the wearing of masks and whether or not that affects the confrontation clause rights? And if it does, what follows from that?
That wearing fast.
Go ahead.
I'm sorry, Your Honor. I didn't mean to speak over you. That wearing face masks is not a violation of the confrontation clause as balanced against the trying to prevent the spread of COVID.
The findings here. If you are conceding that it implicates confrontation clause rights and you are conceding that the judge didn't make Craig findings here, I don't understand why. If you are conceding both of those things, how is this not a violation?
Well, I do not wish to concede both of those things,
Well,
but wearing a face mask would, if it implicates the confrontation.
Does it or does it not?
It may implicate.
Okay, well, if it may implicate it and she didn't make, I'm sorry, and the district court did not make Craig findings, how does that not add up to at least a maybe constitutional violation?
Because what the district court did satisfies the Craig
You
test.
just told me it didn't, that there are no Craig findings in this case. So now there are Craig findings in this case.
I'm sorry, Your Honor. Look, I'll be perhaps I'm misspeaking.
I'm sorry.
The district court did not specifically make Craig findings. We will concede that there were no Craig findings. What the district court did do was weigh the wearing of the masks against the risk to people in the courtroom. And that was couched in terms of the COVID-19 pandemic. And when I was trying to.
But Mr. Gross, the district court never addressed the reliability of the testimony that was going to be admitted with the witnesses wearing masks. You agree, right? And it seems to me that reliability was absolutely key when you have people who were testifying essentially that they committed felonies. I mean, hundreds of Dyson vacuum cleaners, hundreds of hard drives. I mean, these were massive amounts of stolen goods. So why wouldn't reliability be something that the district court, and it gets back to preservation. I understand you're saying that, that the district court wasn't required to address something that wasn't brought up in front of it. But if we get beyond that, don't you have a really serious problem? Because these witnesses, on their face are, the fact that they may have been addicted to drugs when they testified, the fact that they were testifying that they were stealing merchandise and providing it to Mr. Vladimirov. I mean, isn't that the essence of unreliability in terms of a witness? If you know they're a liar and a thief, I mean.
In this case, Your Honor, no. And here's why. The witnesses testified under oath in person and were subject to cross-examination. You could observe their demeanor. You could observe their eyes. You could observe their reaction, their tone. The effect of the covering of the mouth as weighed against the important policy of preventing the spread of the pandemic would allow the jury to still have a complete satisfaction of assessing the reliability, even if there is some effect on the mouth. Yes, wearing a mask would have some effect on the ability to interpret demeanor.
Can I just, so these cases are unfolding around the country. Does the United States have a position on whether the wearing of masks implicates the confrontation clause so as to require the balancing that you're relying on? Or is this just happening on kind of an ad hoc basis?
I would say it's been happening on an ad hoc basis. We've not received formal guidance, but we went through the constitutional hoops because we were convinced that the Maryland versus Craig test is satisfied in this case, even without an express finding. That's what actually happened. They were under oath. They were subject to cross-examination. You could interpret their
I'm sorry,
demand.
isn't the point of Maryland versus Craig that the finding has to be made at the time by the district court? You think that Maryland versus Craig can be satisfied even if the court doesn't make findings, if we can then sort of post hoc our way through the thing?
I would say that Maryland versus Craig does not necessarily require an on-the-record test if the court is able to determine from the record that the other factors were satisfied, which this court can do. Again, there's no dispute that they were under oath, that they were subject to cross-examination. They were physically present before the jury. So whether that issue has to be raised and preserved, I would say there's certainly adequate information in the record to show that all of those factors were, well, I would say conceded. They're not under dispute, and that's as they were analyzed. So with the opportunity to evaluate a witness's demeanor, face, eyes. Some people say the eyes are the language of the soul. I don't know. I'm not poetic, but you could make eye contact. You could talk to these witnesses. You could hear these witnesses. You could react to these witnesses. And as far as I wanted to address your question, yes, the fact that they were drug addicts did in fact come out in front of the jury. It was explored not only on direct but cross-examination. So the jury heard all of that evidence. They heard their responses to those questions, and they heard their role as to what their role in this scheme was. Now, I want to make sure I've thoroughly explored that issue, but other issues were raised in the appeal. But I agree the confrontation clause is certainly an important issue. There was not a Speedy Trial Act violation. Again, that also dovetails into the difficulties of trying cases during the COVID-19 pandemic. And when we look at the Barker versus Wingo factors as analyzed in that case, there was no speedy trial violation. There's no prejudice that was asserted by the defendant at any point in this case. And there was no impairment to the defense, no loss of evidence, no unavailability of a witness. The judge made a specific ends of justice finding for the exclusion of all of those, of all of that. So that issue wasn't even timely raised by defendant or defense counsel under Rule 12. It was just belatedly adopted where it was denied by Judge.
Isn't that how it works? I thought that was our rule that once the defendant gets counsel, if counsel asks that those pro se motions be ruled on, then that is preservation. Is that not right?
Not necessarily. In this case, Your Honor, the judge determined that pro se, he wasn't a pro se defendant. He was filing pro se motions while represented by counsel. Once
counsel says, please act on those motions, isn't that enough to preserve it?
Well, we think not. That's not extraordinarily well preserved, and often this court will instruct
How
us.
extraordinarily well preserved does it have to be?
Well, this court has issued many opinions talking about preserving objections with specificity. When this defendant filed, he filed reams of pro se motions that were belatedly adopted by defense counsel out of an abundance of caution. The court said that she had read those and examined those and denied those. So that was in fact done on the record. But even if that issue is preserved and it's not extraordinarily well preserved, it was funneled through counsel and it wasn't specifically observed as this. But even if it is preserved, we can just dispense with it because there was no Speedy Trial Act violation here. The reason for the delay wasn't some nefarious purpose of the United States. We wanted to go to trial. We couldn't because of the COVID-19 pandemic, or it was otherwise shut down. So that was that. Even if we reach that question on preservation, which is your exact point, Judge Harris, the Barker versus Wingo factors are all ticked off. There is no allegation of prejudice. I'd like to turn briefly to the fact that there was no abuse of discretion by the use of the experts in this case. The experts were noticed nearly a year ahead of time. The questions were conducted. The judge did a very careful gatekeeping and analysis, gave a pretrial ruling that this was specialized knowledge and the United States would be required to show that the experts was relevant and reliable. They did offer special
split between being experts and fact witnesses.
No, they did not, Your Honor. What the experts did was they testified as to how they did. They were initially qualified, as we were required to do. They testified about each and every one of the investigative steps. And as they testified about the investigative steps, then at the end of their testimony, I asked them to draw conclusions to a reasonable degree of expert certainty. That, along with the jury instruction that the judge specifically advocated, along with the fact that there were no objections to the manner in which we were calling these witnesses or any additional requests, is exactly how this expert testimony did not confuse the jury. And as the United States Supreme Court says in the Yates opinion, jurors are presumed to follow the instruction. The instruction the judge gave was spot on. She asked about the frequency. Defense counsel said once at the end of both is sufficient. And both experts testified in a similar way. These were the investigative steps that they did. They provided that information to law enforcement. These were not law enforcement witnesses. These are the investigative steps they did. Now, what is your conclusion to a reasonable degree of expert certainty? That's consistent with Moeller. It's consistent with Wilson. And finally, and lastly, if I could, I'd like to turn to the sufficiency of the evidence. This was also raised on the appeal. This has to do with whether we were able to prove and whether any rational trier of fact could find guilt on a conspiracy to commit a promotional money laundering scheme. The conspiracy to commit a promotional money laundering scheme had to do with how these boosters who were stealing the items were converting the money to cash. They went to the same bank where Vladimirov occasionally withdrew money from the bank when he didn't have enough money to pay them for the stolen merchandise. And he continued to do that repeatedly. He continued to pay them from the same account where he was selling the stolen, or he would get these stolen items, sell it on eBay, sell it throughout the country at below wholesale price, and then eventually transferred $153,000 to Bulgaria, which accounts for counts 2 through 4. In total, Vladimirov had a fair trial. We went through the steps to make sure he had a fair trial. There was sufficient evidence to support his verdict, and the experts were otherwise properly qualified. Are there any additional questions from this court? Seeing none, we would ask that Vladimirov's guilty verdict be affirmed. And thank you.
Thank you very much.
Yes, Your Honors, I'd first address the issue about they said it was a Speedy Trial Act issue, and we're talking about this, and I specifically did not raise a Speedy Trial Act.
Sixth Amendment claim, right?
Well, yes, exactly, Your Honor, and I didn't do that because, he's put in a pretty tough position. His counsel didn't file the motion. He's forced to file it himself. And if you read his motion, he couches it. He specifically mentions the Sixth Amendment Speedy Trial Act in his motion that was adopted by counsel, and it was ruled upon by the court. So there's not a Speedy Trial Act issue. That's not what we raised in the appeal. We raised a constitutional issue. And the counsel over there has said that there was no prejudice. Well, there's 3 factors when you're doing the prejudice: is to prevent oppressive pretrial incarceration, to minimize anxiety and concern to the accused, and to limit the possibility of the defense being impaired. So there's 3 issues, and he only talked about one of those.
But we have said many, many times, I think, that that's kind of the key, the specific prejudice to the ability to put on a defense.
I think you're right, Your Honor. It has been listed as maybe a more, getting some more weight in this case, but you got to think this guy's been in jail for 17 months. COVID, there's no doubt it's serious. He's been subjected to possibly getting COVID. That was actually their objection to one of the motions by the government, was that.
Can I ask you, so if that's enough, it does strike me, a lot of people had to wait a while for a trial during the worst of COVID. There's going to be a bit of a floodgates effect here, right? If it's enough that you waited for, something close to 12 months during the height of COVID, and that is in itself the prejudice. I don't want to ask you to give me a ballpark figure, but that's a lot of people, right?
If some people getting out of jail has to yield to the Sixth Amendment, I'm fine with that. And I think the law should be. That being said, I tried a case in state court right in the middle of COVID, and everything went fine. And the thing we need to remember too about this case is these trials weren't necessarily barred by COVID during a lot of this 17-month delay. they would make a motion to continue due to COVID due to witnesses. And it was always couched in this witness or that witness. No specific witness was ever identified that couldn't be there. So I think that's important to remember too. It wasn't barred. It was their motions for that. Addressing the expert issue.
How long is your client's sentence? Tell me that again.
96 months, I believe. It's right in that 90 something
And
month.
the time that he served before trial counts towards that, right?
Certainly, Your Honor.
And we're still in COVID alert, right?
I mean, COVID is certainly still an issue. I don't know, alert. I don't know necessarily agree with that. I mean, it's serious. Obviously, nobody wants to get it, but it's still around. No doubt about that. Regarding the expert issue, the one thing I really wanted to talk about was calling him a fence, or them being allowed to say that, this was a fencing operation. That was raised pre-trial. And, Mr. Goes said when they had this colloquy before the jury was in there, he said, I'm familiar with 704B, which is that you cannot go to the defendant's mental state as an expert. They can't go to criminal intent. All they can say is this is consistent with the fencing scheme. And then they've alluded in their briefing that somehow we invited this error later. But they were specifically asked not whether this was consistent. They were asked on direct. Nihas, the expert from CVS, I believe, are your conclusions concerning whether this was a fencing operation based to a reasonable degree of certainty in your field? Absolutely. That's not, is this consistent? That goes straight to his mental intent, because they cannot dispute, because they've said it on the record, that a fence is someone that knows they are receiving stolen goods. And in this case, by calling him a fence, by saying this was a fencing operation, it's directly to the knowledge portion of that. So they also asked him on direct, all these factors together, this is Varela, the other expert, I'm easily able to determine that Mr. Vladimirov was in fact running a fencing operation that was buying stolen merchandise from multiple addicts. That again goes directly to the mental state of the defendant, which 704B specifically bars. Seven rules say that yes, just because it's the ultimate issue doesn't mean you can't do that. But in this case, they specifically opine not that this was consistent with things. They went beyond that pretrial ruling and said this was a fencing operation. And that was on direct, not just raised on cross-examination. Also, basically what these experts said was common sense. I mean, everybody knows how stolen merchandise works. There's certainly reasons why you would buy something for a low price. But at the same time, everybody knows basically what these guys said was he should have known, because it's common sense that if you buy for a certain price, that is stolen, or if you sell for a certain price, it's stolen. Basically, everything these experts said was simply common sense and didn't help the jury at all. And as you alluded to earlier, Judge Motz, they're questioning. It went back and forth between expert testimony and factual testimony. Now, there was a curative instruction given. I'm past my time. Can I finish?
Just finish up this last point.
But a curative instruction being given, I think basically that just spotlights it. The case law shows there are other factors that should be done, such as allowing him to testify at one part as a fact witness, as another part as an expert, or require counsel's question.
Mr. Weston, did counsel ask for those alternate remedies?
I don't believe he specifically asked for those remedies, Your Honor. It was brought up I think basically it was brought up. He raised the issue in the colloquy beforehand as, are these people assisting the jury and figuring something out, or are they just helping the prosecution present its case? Thank you very much for your time.
Thank you. And Mr. Weston, I see that you're court appointed, and we especially thank you for your assistance today. We thank all counsel for their help. We're sorry we can't come down to greet you, but we wish you the very best. And I think we are ready to adjourn for the day. Adjourn court.
This honorable court stands adjourned. Sign and die. God save the United States and this honorable court.